Everyone, and welcome to our scheduled zoning board of appeal meeting. The time now is 5:02. We're going to bring this meeting to order. It is our custom that we begin by.
It's not ready yet. We're having trouble with the Zoom link. As far as it being televised, it's up and running. The Zoom link for someone to participate is not running correctly. So I'm trying to fix that right now.
What item is the Zoom item?
She's item number. Because I'm creating a whole new. It's either 14 or 18.
So if we go ahead and get started, I mean, by the time you get to her, we should be up and running, hopefully. And again, it's our custom that we begin our meeting by reciting the Pledge of Allegiance. So if I could ask you guys to stand, face the flag, recite the pledge. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I think we are good with our public, with all our notices?
Yes.
Okay. Adoption of the agenda, of the amended agenda.
So moved.
Second.
So it's been properly made in second. All in favor?
Aye.
Approve the agenda. Our May 26th and June 23rd meeting. The May 26th meeting have, I think everyone was here for that May. Everyone have a chance to look at it? All right. Can I get someone to make a motion to adopt the May 26th meeting?
I'll make a motion to adopt the minutes from the May 26th meeting.
I'll second it.
Properly made in second. All in favor?
Aye.
Okay, the June 23rd meeting.
I wasn't here.
I was gonna
And you
accuse
wasn't here,
myself
so
since I
1,
wasn't
2,
here.
3, 4. Yeah,
We got enough?
well, you wasn't here either.
Enough to do it?
Yeah. Yeah, we
I
do.
moved it.
Okay, you were here, you were here, yeah.
We
Okay,
got 4, we got enough.
so you made a motion?
Yes,
to-
sir.
Second,
So it's been properly made in second. All in favor that was here to adopt the June 23rd meeting. And we note that Ms. Jane and Ms. Hughes wasn't here on that June 23rd meeting. All right, moving to item number 6. Note that all applicants have 10 minutes to present their case. Attorneys, we give you 15 minutes. And all public comment, you have up to 3 minutes. So if someone, if you have a case where someone has said pretty much what you wanted to say, just say, hey, I agree, state your name, and we can move forward. All right? So with that being said, item number 6, Mr. Wayne Willenberg. All right, so he's a no-show again. I think he had been a no-show last month.
yes,
I think
sir.
we need to move forward on this case, and in his absent,
Yep.
I move we disapprove it because of the covenants.
okay,
I second.
well, before we do that, do we want to just do the public comment, make sure no one is here before we?
Sure.
Is anyone here, public comment for item number 6? So we close that public comment.
I move that we disapprove it because the submittal does not meet the criteria for a special use permit because of the covenants on the property.
A second.
So motion's been made to disapprove item number 6, and it's been properly made in second. All in favor of disapproving the item number 6, special use for Mr. Wayne Willenberg, signify by raising your hand. Thank you, so that has been disapproved. Item number 8, Mr. and Mrs. James Ware. I believe they're going to be presented by Mr. Tom Taylor. Mr. Taylor, you have the floor.
Mr. Chairman, board members, good afternoon. It's nice to see all of you all again. I am here today very, very proudly to represent 36 homeowners in the Buckingham Plantation neighborhood, which is one of Beaufort County's oldest and most unique neighborhoods located at the base of the Hilton Head Island bridges. Everybody here hopefully has seen it and knows a little bit about the history of it. It's just an incredibly unique area. 5 years ago, the residents of Buckingham Landing came to the county's aid and graciously and open-armedly welcomed the emergency necessity of placing the Dubose Island Ferry Terminal in their neighborhood. They were promised by county agents and by county council members that it was going to be a temporary basis, and like sometimes happens, what was temporary turned into being long-term and now appears to be on the way to almost being permanent. 5 years down the line, this small neighborhood is literally overwhelmed with tourists and Dubose Island, the few Dubose Island residents who actually use the ferry service. It is by far and away Hague Point's main source of income is their tourists that they bring through there. And we're going to show, if you will, in a few minutes, some pictures that I think will give you all a little bit of an idea of what has happened over the last 5 years. I have provided you all with both an initial application and a supplement. I am going to try to not get off point and talk about what I think has been some intentional slowing down by, unfortunately, the county staff on responding to many things. And I'd like to try to focus just specifically on the two major issues that we allege. And that is that Mr. Merchant's letter of determination of April 21st, 2022, that found that the operation of a commercial ferry service in Buckingham Landing is not in derogation of the Community Development Code nor of the Buckingham Landing Community Preservation District. That is wrong as it can be. The county understands and knows that this commercial ferry has no business here, but in order to buy some more time, they have come forward with an interpretation that says, based on Wilbert Roller's variance that this board gave him in 2008 to tie up boats for his restaurant, that somehow that can be bootstrapped into a complete commercial application of any type. And that's just, we believe, completely wrong. And for purposes of kind of trying again to, I don't need to go into, y'all I know have read the application. We made, on behalf of the Neighborhood Association, a request in March of 2021 for a determination. It took 6 weeks for the county's attorney staff to finally say, we're not going to basically tell you, you can read it. We then filed suit last June on behalf of 36 property owners. The county moved to dismiss it, saying that we had not adequately exhausted our administrative remedies. Judge Goodstein tossed that and said, no, there's a provision within the code that allows them to continue. But as a matter of last resort, we filed this application and went to the, first we went to the county and asked them for an interpretation, and we asked Mr. Merchant to look at it and to determine that clearly the seafood restaurant, which had been closed in 2013, and you all have an affidavit in front of you, and there is no other, nothing to contradict this, that usage of that seafood restaurant, which was at one point in time granted by the county to be a non-conforming use, was or had to have been abandoned by the October 2014 time period because a full year had gone by under the CDC. Under the Buckingham Landing Community Preservation Plan, there was only need for 120 days to go by. But either way, that property has been abandoned and no more use could go forward with that specific property. You all are aware, because I'm sure you've read the letters from Mr. Merchant. I would like very briefly, for purposes of the record, to call Mr. Merchant as a witness. It'll take about 2 minutes. Mr. Mack, he is here and present.
Your Honor, Mr. Chairman, I'm Danny Crow. I represent the planning director. As you know, the calling of live witnesses is improper. An appeal from an administrative determination. The only issue, the only thing allowed under this board's rules are argument on the record of appeal. So calling of witnesses, live testimony would be inappropriate.
Mr. Chairman, actually, the administrative rules of this board provide that this board may subpoena witnesses for administrative reviews, and thus clearly the calling of witnesses. And Mr. Mack, I know you've been here before when we have done just exactly that on these reviews of administrative appeals.
Mr. Chairman, we object. We think this is highly irregular and inappropriate.
Yes, sir, and I'm gonna deny that.
Deny the request to call
Yes.
Mr. Merchant.
Yes, sir.
All right. Mr. Mack, if I could, just to perfect the record, I'd like it to be, we would just call it the proffer. The only thing I intended to ask Mr. Mack, or excuse me, Mr. Merchant, was of his September 20th, 21 letter to me, he had indicated that the county would need this time, 60 days, to contact all the appropriate parties, gather all the evidence, and make careful review of all the facts. That's what I intended to ask Mr. Merchant, was what he did, because what has been given to us and to this board does not indicate that any of those three things were actually done, and that the only thing that was done was taking Mr. Crow's email that you all have in front of you and making a letter from that to say, this is what the county's position is. I would like to ask, Mr. Chairman, that you all focus with me on one other thing. The supplementary memorandum that we sent over really draws the focus of this, I believe, to what it needs to be, because the county is trying to take the position that this is not a commercial use of property, that it's just the dock. And because Wilbert Roller got this board to say it was a commercial dock, then they can do anything they want to with this property. Clearly, that is not the case. And if you all read the supplemental memorandum, you'll know that the actual finding by this ZBOA in 2008 was that it was the commercial restaurant that was the use of the property. The dock is not a land use in itself. It is solely associated with and related to the business on the land. It serves, in other words, as an amenity to the restaurant, but does not involve any independent commercial use. And then the last and most important thing that was in this board's variance, of which the county now relies, is the provision that the dock is an incidental amenity or practice. This variance, as granted, is not a use variance. This board never gave a use variance for that property. That property is zoned residential. It was a non-conforming use for some time as a restaurant because there were county issues involved with the denial of the permit when we enacted the 300-foot limitation. But clearly, as of October 2014, that had to have been abandoned. And for the county to come in 2017 and take the position that they're now going to operate a commercial entity out of this is a slap in the face, literally, to the residents. But they went ahead and have gone with it. And we are here today begging this board to look at this and understand that, as with any of the historic neighborhoods in Beaufort County, we have worked over the years to try to protect them. The Buckingham Land and Community Preservation Plan provides, it is the essence of this, the intent of this plan is to conserve the existing residential neighborhood and to improve the quality of life and public safety for their residents. This is a residential neighborhood. There are five commercial uses like a bed and breakfast and the four other ones that are cited in here. But guys, this is way beyond anybody's use and anybody would ever have envisioned for this to have been. These people have given the county 5 years of their neighborhood, and it is time to bring it to an end. And I'd like for you all to take a look at some of the photographs. We have 16 photographs, Your Honor, and if Mr. Crow wants me to authenticate them, I'll be delighted to call Amanda and have her authenticate them.
Mr. Chairman, my interest is not authentication. Again, I object to using these photographs. This is not the proper procedure on an administrative appeal. This would be new material, does not comply with the 5-day rule in this board's rules of procedure for submission of supplemental materials to the board in advance of a meeting. These are brand new materials. I've not even seen them, and I object to Mr. Taylor presenting them tonight.
I'm sure that you all may have an interest in actually what this neighborhood looks like, thanks to the Commercial Ferry Service. I would urge the board to take the opportunity to look at it so that you can judge exactly what they have turned this into.
And with that explanation, I would also argue that it's irrelevant to this appeal. which is strictly about the effect of the zoning permit.
How many photos do you have? Mr.?
16, sir.
16 photos?
Yes, sir.
I don't think it'll be an extreme harm to view those photos.
Thank you. They're teed up and they can go relatively quickly.
Yes.
They are working in the front.
The chair is denying my objection, is that correct?
Yes, sir.
Rob, you can go through them as fast as you, or
Okay,
if it's
they're
time.
on a timer.
Oh, I'm sorry. Whatever is convenient for the board is fine to me. Chairman, thank you very much. That concludes the petitioner's case.
Mr. Chair, members of the board, this is my first appearance before you, and I think just very quickly I'd like to tell you a little bit about me. My name is Danny Crow. I'm a lawyer in Columbia. I've been a lawyer since 1975. I've been representing municipalities and counties since 1977, focusing on zoning and licensing issues. I'm currently the city attorney for Casey, the general counsel for City of Sumter, and formerly general counsel for the Municipal Association. That's just by way of background, so you'll know a little bit about me. I was hired by the county in June of 2021 to defend a circuit court lawsuit that was brought by the appellants here, the Wares, the Duboses, and 32 others in Buckingham and Landing for money damages, as well as declaratory and injunctive relief for an alleged unconstitutional taking and nuisance related to the county's providing of a public ferry service to Dubose Island from Buckingham Landing beginning in 2018. When it became clear that the litigation had become interlaced with this appeal to the board, the county asked me to represent the planning department in defense of Mr. Merchant's administrative decision and this appeal to the board. First, I do want to thank you for giving me a continuance from the June meeting. The day before the board meeting, I tested positive for COVID, so I didn't want to come down here and risk spreading COVID to any of you. I'm fine now. I was one of the blessed and lucky ones who had a mild version, but I do appreciate your thoughtfulness in continuing that hearing in June. Also, Mr. Chairman, I would like to state for the record my objection to the materials submitted by Mr. Taylor that are not based, that are not the materials that were available to the administrative agent, the planning director, in rendering his initial decision. As I understand Community Development Code Section 7.3.70, this appeal is limited to consideration of such materials as were considered by the administrative official in the decision. Therefore, any supplemental materials would not be appropriate for consideration by this board. In the event that it also becomes an issue, I'd like to object in advance to any attempt for a show of hands or standing or similar demonstration of support for the applicants here. That would be inappropriate and not proper argument as well. The April 21, 2022, we have a photograph just for general information, if you could bring that up, not as evidence, but just to show the board the location of this property. This property is at 35 Fording Island Road in Bluffton. It is just off Highway 278 at the bridge from Bluffton to Hilton Head Island. If you look down to the right with a slightly different perspective, this is what you'd see. The saucer-shaped buildings are the former restaurant that you've heard about. The white road that comes down from the left corner to the middle of the photograph is Fording Island Road. That's a state-maintained road. It terminates in a public boat landing, which has been present there for many decades. Formerly, I understand, in the past, this was the site of a ferry to Hilton Head before the bridges, apparently. The dock at issue is shown jutting out from the circular shape in the upper middle down the walkway of 300 feet to the dock that shows another boat present there now. The house of the Wares is on the left edge of the photograph.
Is that where the smaller boat is in the yard you were referring to?
Yes, sir. Just that, and all that's just for orientation. The parking that you see presumably is used for the public boat landing as well as for the ferry service. This property that's shown on the upside of Fording Island Road, is owned now by the county, has been owned by the county since 2018. That's just for orientation again and not for evidence. The April 21, 2022 determination by Mr. Merchant as Director of the Planning and Zoning Department is concise, it's clear, and it's correct. It contains no error and should be affirmed by this board. The determination says this property, which was subsequently acquired by the county, has a county zoning permit for a commercial dock. The zoning permit is consistent with the OCRM construction and dock permit, on page 2 of which it states the permit is for commercial use and the docking of boats. Importantly, the county zoning permit, although it has a space, as you'll see, for conditions, states no conditions except that it's issued pursuant to the zoning board decision in 2008 and in accord with the OCRM permit. It has no other conditions about the circumstances under which the permit is to operate. It contains no restrictions, no limitations, no expiration date. As pointed out by Mr. Merchant in his April letter, a variance permit such as this runs with the land under section 7.2.140E of the CDC. It is not affected by subsequent change of ownership. So the county gets the benefit of the commercial dock permit issued by the county when a private party owned this property. The county zoning permit, importantly, is not conditioned on any language of the zoning board order of 2008. It could have said this permit to be used in accord with the findings of the zoning board's order of 2008. It does not say that. When we blow away the smoke from this appeal, and I'm talking about the applicant's comments about Mr. Merchant, comments about his procedure for the determination. There are comments about me. There are references to county lies and collusion between me and Mr. Merchant and the lack of good faith by the county. When you blow away that smoke, and when you remove the mirrors, such as the references to the community district zoning and the community preservation plan, which were in effect and known to the zoning board in 2008, when it granted the variance permit for a commercial dock, if you remove those mirrors, if you disregard this kind of scorched earth language of the litigation, this vitriolic language about lies and collusion, lack of good faith, what you are left with is a valid county zoning permit for a commercial dock. That's what this case really comes down to when you strip away all these irrelevant factors. This board cannot and should not now, 13 years after the permit was issued, modify that permit by either dissecting the language of the order, as the appellants would urge, or by tying it to a restaurant use for the property that formerly was a restaurant. These were not conditions that were placed on the permit by the zoning board in 2008. Again, they could have been, but they were not. This is not a situation in which consideration of non-conforming use is involved, because the dock and the commercial purposes of the dock, as described in the OCRM permit, are expressly permitted by the variance permit. So the idea of non-conforming use does not apply. Similarly, consideration of whether this restaurant use was discontinued is not relevant, because this is not a non-conforming use issue. This appeal is not about whether the restaurant use was discontinued, but it's about whether the zoning permit for a commercial dock remains valid, and it does. Also, I think it's important to mention that this is not a situation of the county taking advantage of a neighborhood. In the wake of Hurricane Matthew in 2016, action was required to maintain the ferry service to Dubose Island. Now, Mr. Taylor's clients may not like the people who ride the ferry, but this is a public ferry service to Dubose Island, which, as you know, has no roads that would take from the mainland to Dubose Island. Buckingham Landing is not a permanent solution in the eyes of the county, and the county has new ferry sites in the works. The county zoning permit and the OCRM permit for a commercial dock allow the dock to be utilized for commercial purposes. That is the effect of the zoning board's 2009 variance permit. The county planning and zoning department requests that this board uphold the determination of Mr. Merchant that the ferry service is a lawful use because of that county zoning permit. Mr. Merchant will be glad to answer any questions that this board might have, not Mr. Taylor, but this board might have. And I'll reserve any other comments for the reply period. Thank you very much.
Thank you, Mr. Grove. Do anyone have any questions for Mr. Merchant himself? There are questions for Mr. Tom Taylor. Anyone have any questions for Mr. Tom Taylor? I'll allow you guys to go first.
Mr. Taylor.
Mr. Nielsen, nice to see you.
I'm Dennis Nielsen, nice to see you. I live not very far from there, so I'm kind of familiar with the area. When the people who come to get on the ferry, this is not exactly right next to where people live, is it? That is, they would have to walk from where they park a half a block, whatever, to someone's home, which they should not do. I mean, I'm not saying that. But I don't know if there was any problem when the restaurant, was there. Did it bother the people in the community? I don't know. So I don't see where where the community is being overwhelmed by the picture and by the area. If the people walk over to it, yes, I understand that, and maybe there should be some kind of signs or punishment or something for them to, walk over on somebody's private property. That's not the thing to do, but they'd have to walk to it. It's not like getting out of their car and stepping on it unless they're illegally parked.
Mr. Nielsen, if I
Yes.
may respond, actually, of course, not surprisingly, the photo the county chose to show as an exemplification of this does not show a lot of the additional parking that you saw a few minutes ago in those other 16.
Excuse me, Mr. Taylor, not to interrupt too much, but if you could go to the podium for those that are listening.
Exactly right.
Yeah.
Thank you, Mr. Mack. I'm sorry. This is a situation where, because of the hundreds of people that are coming in every day, they aren't just parking, sir, where you see this now. They park all the way down the road to the gas station and then also off, and the buses bring them in. And one of the most dangerous things for the neighborhood is the access up and down this roadway, which used to be mainly just the people who were coming in with a few of their private boats. And now it is, as the photo showed earlier, a lot of speeding, a lot of people walking up and down through there. All of the people in the neighborhood have been affected, and it is not a separation, Mr. Nielsen, that is comfortable or convenient as those photographs showed up there. The people who come and wait tend to walk around, look around, have their dogs run into the residences.
I know, but if just for argument's sake, not making a decision, for argument's sake, if the restaurant is there, they could be walking around also.
Yes, sir.
They could be.
Yes,
Okay,
sir.
they're, whether they were or not, I don't know. But any time you have some kind of a business, a commercial business, that's not very far from a residential area, people are gonna walk. And that's not good. I'm certainly not advocating that, and maybe there should be some kind of, not a fence, but some kind of a thing to say, this is private property and you cannot come on it. You know what I'm saying?
Yes, I do. The county will admit, Mr. Nielsen, I believe, that the restaurant is in the Buckingham Landing Preservation District and is a residential zoning, except for the bootstrapping that they want this board to buy into. It is all residential. And yes, they were not happy with the restaurant, and I'm sure there were plenty who were glad when they abandoned it.
Yeah, I was surprised that it was built there, to be honest.
What is it just abandoned now?
Yes, ma'am. It is just abandoned, except for the county and Hague Point have slowly opened up. They are now leasing the smaller whole building that they have there, and it's all used underneath for parking and for people trying to get out of the sun and that type of thing.
I have a question. I know it's expensive it's not a free public ferry.
Yes, ma'am.
You have to pay, and you also have to pay to park there, and people leave their cars there for a week or more. Who gets the money? Who owns it?
The really interesting thing about that question is that when Beaufort County started providing this ferry service 40 years ago, it was for the residents of Dufusky, and that's who it was always intended for. And if this was only used for them, it would not be a problem, because there are probably on any given day 15 people who might take that are residents of Dufusky. What has happened is the county has entered into money-making contracts with Hague Point, and more than 90% of the people they are moving are paying tourists whose money goes into Hague Point's pocket and who then pay the county a portion for that contract. But that's really the guts of this. If this was just Dufusky Island people, these neighbors would not have a problem with it. It's a commercial enterprise running tourists back and forth to Dufusky. And that's not what the county signed up for 40 years ago when they elected to provide this service. It's just a way that they can finance it better. And the county doesn't actually have to spend any money. Hague Point makes a lot of money.
You said there are parking underneath that, I would say, smaller saucer?
Are they parking under the smaller building or just using the inside of it?
No.
Sorry, Mr. Administrator. Okay, I don't know the answer to that question. They are renting the small building for use under their lease, and that lease is enclosed in the packet.
Sir, I have a question.
So, Mr.
Sort of based off what you just said, that the people wouldn't object if it was just Dubose Island residents. So the opposition isn't to a commercial operation then. It's to the people running around the neighborhood.
Well, Mr. Chesney, the commercial operation should not be going on in the neighborhood. But this neighborhood graciously allowed it to be used, and they have done so. And I guess I'm speaking for them, and maybe I shouldn't. I'm just saying that if it was truly those people from Dubose who don't have to pay Ms. Hu's money, actually, because if you're a resident of Dubose, it's part of what the county services are for Dubose, I believe still it was when I set up there. But it's the tourists who pay the money. But, Mr. Chesnut, we certainly do not believe the ferry should be running from there. One of the things that I didn't say, but which is incorporated in here, of course, is that under the county's CDC, Pinckney Island is designated as the ferry terminal point. It's written in the ordinance, and that's where at least it should be. Anything else, Mr. Chairman?
I'd like to
You have
ask
a lot of
Mr.
things to do tonight.
Merchant a question. I'd like to ask Mr. Merchant a question.
Okay.
Well, yeah, no, the lawyer.
Cook?
Oh, yeah, I'm sorry. Yes, I'm sorry.
Crow.
Forgive me, please.
Danny Crow.
I'm sorry, I
That's all right.
get confused. My question is that I believe that the permit was issued in 2017, is that correct? Something like that? When was it, the permit?
The permit was issued in 2009,
2009.
after the zoning board's
Gotcha.
granting of the variance in 2008.
And I believe you said that the county has plans for new places.
Yes, sir.
How come they haven't had new places since 2009? In other words, that's a bit of time. When will they make some decision that this will no longer be, be used for that, and there'll be new places?
The short answer would be, good question. The short answer is Hurricane Matthew hit in October
Yeah, I
of
understand.
2016. So there was not a need to use another embarkation, debarkation point before Hurricane Matthew hit the point that was being used for the ferry at that time. In February of 2017, the service relocated to Buckingham Landing with a lease between the ferry operator and Mr. Roller, who you've heard about, who owned the property at that time. The Roller property then went into foreclosure. The county acquired the property in order to maintain the use of that site and the commercial dock. So since the county obtained the property in 2018, it has been looking for alternative sites. Why that took so long, I can't give you a complete
Don't
answer
you?
to that, except the acquiring of property, the locating of property, the acquiring of property, et cetera, is a time-consuming process. So it is in the works, however.
It's a difficult answer to it. However, if you are a resident there and there is somewhat of a period that it's going to be some other place, they may be more willing to accept it than if they have no idea, it could be 100 years from now that you changed the dock. You know what I'm saying? In other words, it's like putting out, we're gonna move it. That's the county's plan, so well, you can tolerate it till you move it, but if you don't know when you're gonna move it, and that could be 25 years, that ain't gonna work too well for the residents. However, if you do move it, say in a reasonable amount of time, the residents may be less, they're affected, but they may be less, upset about it because it's going to be gone.
I do appreciate what you're saying. Those efforts are underway. I don't want to get into too much. There has been some public action by the county council with regard to those locations, and finding other locations is underway. I can say that. I know the county would like to have moved more quickly as well. I do want to respond to one thing. I'm advised that the county pays for this public ferry service to the ferry operators. The county does not make a profit from that service. And also, as you can imagine, it is wrong to differentiate between residents and tourists when you're operating a public ferry service that takes the place of public roads. You couldn't very well
I have
say
a
no
question.
tourists are allowed to drive over to Dubose.
I have a question.
Yes, ma'am.
You are relying on the dock permit that was issued by OCRM, which is a state agency that says it's a commercial dock. But our document from the variance says that it's just, it's not a use variance and that the dock is incidental to the use of the restaurant. And I think that we should rely on our own zoning Board of Appeals action instead of what was written on the OCRM permit, which was probably not coordinated with the zoning Board of Appeals ruling.
I do, thank you. I understand exactly what you're saying. We are relying on the county zoning permit, which should be in, it's the third document under the information the planning director reviewed. That zoning permit has a place for conditions. It refers to the ZBOA's approval of the dock variance on July 24, 2008 for the OCRM permit.
What's also is something is scratched out and commercials written on theirs, there's no note on who did that or if that was done after the fact.
It says under applicant's name, Wilbert Roller, Junior Commercial Dock. I don't know the sequence of the commercial dock.
And then it says
Scratch out. I
approved
see that.
use and there's something all scratched out and then it says commercial dock. So I would say that who was that done by? I mean, then that's.
The county issued the permit. It's signed by a county official. It appears to be Lisa Glover. So there's no allegation that this is not in order and properly issued by the county. It's been in effect for 13 years.
Mr. Crowe, so what I understand, it would be the county's position that if there was a restriction on the OCRM permit saying restricting it to the restaurant, the county would agree that the ferry service would be a non-conforming use?
And I wouldn't go that far. There is no restriction on the OCRM. It says on the second page of the OCRM permit document, not the actual construction permit, it says the purpose of this work is stated by the applicant is for commercial use and the docking of boats. So, and that was the application before the BZOA in 2008 by Roller at that time. It was for that commercial use, a commercial dock. That was, I think, clear. So as pointed out by Mr. Merchant in his determination in April, this was a validly issued zoning permit for a commercial dock. It was consistent with the OCRM. It was not tied to the language of the order of the BZOA. There were no conditions or restrictions or limitations put on it by the permit or by the order or directed by the order of the BZOA to be put on the permit. So it's a valid permit that's still in effect. And we would urge that this board find that and uphold the determination of Mr. Merchant. Yes, ma'am.
I would like to ask our attorney something, please.
Yes, ma'am.
Brad Mitchell.
So, may I ask you something?
Do we need
Well, I think we would have to come into
Executive session, okay.
section to talk to him about it. So if you want to move
I like to move that we move into executive session.
Or do you want to take any further?
But before we go into executive session, I think it's good to gather
Yeah.
everything.
Yeah,
Okay.
we can hear it out.
Okay.
Mr. Chairman, I'd like to ask a question.
Yes, sir.
I'm looking at the original variance from 2008, and Mr. Madlinger, back then from OCRM, did state it was a commercial dock,
Yes, sir.
okay? So, I don't think there's
That's
any
correct.
question about that.
I believe it was a commercial dock, correct me if I'm wrong, because there was a shrimp business there, or at least the boat used to sit there all the time. A shrimp boat. And I think that may have been the commercial part of the dock, I'm not sure. But historically, that was there.
Well, the dock wasn't built when this was, when they were asking for the variance
No,
to
I
be
know,
a commercial
I know,
dock.
but
Okay.
it was parked there.
Mr. Crow, how do you square this with the Helker holding, which notes that the use is defined as the specific purpose for which the land or building is designed or arranged or intended? Is it your position that the dock, that being commercial, allows you to change the use of the property?
My view is that that would be the effect of this variance permit that was granted, this permit for a commercial dock. So it was granted because the purpose of a commercial dock would be commercial purposes. That's the OCRM definition of commercial dock, and that's sort of the rational, reasonable relationship. So in granting the variance in 2008, the zoning board allowed a commercial dock and then allowed commercial uses for the dock. This is a highly unusual situation.
So it could have expanded, so by virtue of the dock being there, it could expand the non-conforming use that was approved. The non-conforming use, as I understand it, was the restaurant.
That's correct. The restaurant was the non-conforming use. Once the permit was granted, non-conforming use no longer came into play because it was a permitted activity, like a by right activity. So the activities on the commercial dock were allowed. That's the effect of the zoning board decision in 2008.
Is there a legal, what's the support for that as to the base? Do you have a case that you're basing that on?
Well,
The permit changes the use as to that?
I have frankly been able to find a case on all fours with this situation. If I had one, believe me, I would hand it up. But I can't find one on all fours, and I can't find one that says that is not the situation. So I think what the board is left with is determining whether this permit is valid.
Well, because what it does seem fairly clear from, the Court of Appeals decision in Helker is as that use being determined by what's primary to the property. And it seems the county's taking the position that because the commercial dock was granted, it could makes all the other stuff irrelevant, effectively. The abandonment of the purpose and everything is to that. What's the point of having any of the other stuff?
I do agree with that the granting of the variance permit made all these determinations about non-conforming uses, abandonment of the restaurant irrelevant to the decision.
And so you're relying on this zoning board's decision to grant the permit when in that order we expressly state that, hey, this permit is not granted, the variance is not granted as a use variance, and that the dock is just incidental to it. But it kind of feels like a Trojan horse there.
Well, I think, and this is a good question, but I think it's clear that the zoning board in 2008 could have said when it granted the permit, the granting of this permit is conditioned on the continued activity of the restaurant. It did not do that. So you have a commercial dock permit that stands alone and is valid. That's the situation.
And so then anything that can be done on that commercial dock can be carried out on the land that it's incidental to?
That would be our situation, and I
And so
believe.
the CDC, it wouldn't apply as to whatever that land, that kind of seems a little.
That would be my understanding.
Okay. All right. That's clear.
Any other questions?
Not for me. Thank you. Did you want to go ahead and make a motion?
I would move to go into executive session, or do you want, do we have any public, do we take?
No.
No, they don't get public comment. I second it.
I'd move to go into
So
executive session.
it's been made that we go into executive session, and
Should we go in the conference?
Yeah, that's where we're gonna go. And it's been second, all in favor of executive session. We're gonna go into executive session, and we're gonna bring this meeting back to order once we return. Yes.
Gentlemen, when you do a motion to go in executive session, you give list the reason why. So I would suggest that maybe you do another motion, go in executive session receive legal advice, just to make sure that somebody doesn't challenge later.
I would move that we, or to clarify that, I'd move that we go to executive session to receive legal advice on certain of the issues before the board in this matter.
I'll accept that change of the motion.
It's been properly made and second, all in favor of executive session. So we're gonna be moving into our executive session and we'll return here shortly. order.
Do we have to move to come out of it?
No. Quite sure there are some questions that some of my team members would have for, I don't know, who would you like to bring up first?
I'd like to ask Mr. Marchant a few questions.
Rob?
Mr. Marchant, in issuing your April 21st, 2022 determination, can you tell me what steps you took to investigate whether there had been a discontinuance of the use of the property under 8.2.440?
We did take steps to do that, initially focusing on the restaurant until we realized the nature of the commercial dock permit. And so we changed the way that we were investigating based on that.
What did your investigation of the restaurant find?
What we were not able to come up with is a determination of when it closed. We were going by, we had looked at different articles of when it was in the paper. We were having a difficult time pinpointing the exact date that it closed.
But it would be safe to say that you didn't find any use of the property as a restaurant during your investigation? Or did you?
All I could say is that we were not able to determine when it ceased to be a restaurant. But that particular part of our investigation was superseded by looking at this in a different way and looking at the actual permit for the dock. So that was not the way that we determined whether this was a legal use or not.
Did you look, if the restaurant ceased use, then the dock was not used since it was incidental to the restaurant? Did you explore that?
Did we?
Since the dock was connected to the restaurant and the restaurant was closed, did you explore that the dock was not being used either?
Well, what we determined is that dock it was permitted, it was issued as a county permit. So there's an OCRM permit for the dock, but there's also a county permit for the dock. And the reason that the county issues a permit is that we have a dock ordinance that governs on small tidal creeks both the maximum length that the dock could be, but it also restricts commercial docks on small tidal creeks. And that is what the ZBOA, in their decision in 2008, allowed for a commercial dock in that location. So because that determination was made through a variance, it has a different, we do not treat that as the same way we would treat a use. In a use, there's a certain period of abandonment, and then that non-conforming use ceases. It no longer exists. With the commercial dock, which was issued under a variance goes with the property, and unless there's conditions stipulated, the variance, that permission as a commercial dock does not go away, regardless of whether there's a period when it's not being used.
But do I understand that you considered the 2008 order as part of your investigation?
We looked at the action of the ZBOA in the minutes, and we looked at the county's permit. And I spoke with Hillary Austin about the nature of the order, and from my understanding, that order is meant to justify the decision of the ZBOA, but the ZBOA in 2008 placed no conditions on the issuance of that variance, and there's no conditions in the county permit.
But ultimately, there are conditions tied to the use of the land, which the dock is incidental to, correct?
We're talking about the commercial dock. We're not, we didn't look at it as incidental or ancillary. We're looking at the permit for the dock.
So you're saying our sole purpose here is for the dock itself?
Yes.
And not whether the non-conforming use had been abandoned.
Correct.
But isn't the non-conforming use on the land part of the property, which would have the parking and the support for the commercial dock, which seems like those would definitely be tied together?
Well, this was issued as a commercial dock, and that is how it is functioning today. And the parking, and I believe that there are facilities, restroom facilities in those buildings, those are ancillary to the function of that as a commercial dock. That's, we're looking at the actual permit that was given by the county.
In your September 20th, 2021 letter to Mr. Taylor, you had said you were considering whether the commercial ferry operation is operating as a legal non-conforming use. But then you ultimately changed your analysis of the issue at some point during your investigation. Is that what I understand? Because that's not the question that your April 20th, 2022 letter answers, correct?
Well, what we determined is that it is a legal use because it is a commercial dock that was permitted, and it was a variance that was taken by the ZBOA in 2008. A variance goes with the land, or it goes with the property. I mean, the letter that I issued in September was in response to the question, the request that was being made for me. But when we did our analysis, that is when we looked at the actual permit issued for the dock.
Any more questions for the county? I just have one question, and I don't know if it's even relevant, but if we were to find that, this have been a error in the administration, what happens to that dock? Do that ferry still operate from that dock, or to transfer the folks to the Buckingham? Or what happens at that point?
If there's an error in the administration?
Yeah, if we find out that, that the county erred in error and I'm just hypothetically speaking,
Yeah, and I think, I don't know if I could have, this is, from what I understand, this particular determination that was requested is part of an ongoing lawsuit with the county. So I am not clear on what the next steps are depending the outcome of this particular meeting. I don't know if that's something that you can speak to, or?
I mean, if someone have to can clarify.
Mr. Chair, my position would be that if the board determines,
Can you come to the mic?
if the board determines that the planning director erred, the next move by the planning director would be to move for reconsideration by the board. If that fails, to appeal the board decision to the circuit court and move to stay the litigation pending the outcome of the appeal to circuit court of this board's decision. So it would be even more interlaced with the lawsuit if that were the result.
Okay.
For the record, if I may, I would agree with Danny's assessment of that. That is how it would operate. And I would ask that the board also not make your determination based upon that, because there is certainly a method of appeal that the county could take.
Oh, yeah.
And the ferry would run tomorrow, I guess, if that's the question.
I'm just asking. All right, any more questions for anyone? Guess with that being said, I guess it's time that, guess we can have some, can put a motion on the floor, if someone have a motion, or we can have a discussion.
We have public.
No, you don't have public comment on,
Well, this time, I would offer a motion to reverse the decision of the county for failure of the decision-making in determining the standard under, as to whether there's a discontinuance of the use under 8.2.4 and following those 7 steps, and so that's moved to reverse the decision.
I'll second it.
So the motion is to reverse the decision of the county based on 8.2. We said 4, that was?
Well, whether they made an error in determining, I think the county made an error in determining whether the standards that they were to consider this were met underneath here and following the discontinuance of the use in determining whether there had been.
Okay. So there's a motion on the floor to reverse, and it's been second. So all in favor of the motion that's on the floor. So when we reverse, and just out of clarity, that doesn't send this case back to the county. When we reverse it, that just, we make clarity on those 7, what is it, 7 steps that they should be considering?
Well, all we have is as it outlines, is the reversal of the decision. As to the reversal of the decision or the interpretation under the 7 factors that are supposed to be considered.
Okay.
Under 8.2.40.
2.40. All right, so there's a motion on the floor to reverse, and it's been properly made and second. All in favor of reversing based on 8.240. All in favor of the reversal, could you just signify by raising your right hand? So that's
We need to recount.
1, 2. So I guess the motion's actually, so it's actually 3 and 3. So actually the motion fails.
Well, you didn't ask who's opposed.
Anyone opposed to the reversal?
I am.
Any unreadiness from anyone? No. So with that being said, the motion actually failed. So when the motion fails, it actually goes back to the. So when the motion fails, so we go back to the, you just.
Have to have one
Well,
passed.
the chair could entertain additional motions, but for that motion to fail, the effect, as I understand it, Mr. Chair, would be that the applicant's requested review is denied because the applicant has the burden. So a 3-3 vote does not overturn the administrator.
That would be my understanding too, Mr. Chairman. That tie vote would result in the appeal being denied.
Correct. All right. That said, that mean that the appeal was denied. So we're moving on to item number
12.
12. Mr. Mike Vaccaro.
Thank you. Thank you, Mr. Chairman.
Just a moment, Mr. Vaccaro. Let me just get your.
Oh, sorry. Getting out of my space over here.
Yes, I'm partially in your space, I guess.
What's that?
Yes, I'm partially in your space. Yeah. You can go ahead.
Good evening, ladies and gentlemen. My name is Mike Vaccaro. I'm representing Craig and Kelly Turner. They are my clients. I'm an architect. I live and work in Beaufort County. I'm a Hilton Head-based architect. I've been here for, I moved to Hilton Head in 2001 and opened my practice in 2003 with a focus on, funny enough, the Fusky Island. Hopefully not as controversial as this last item. What I am bringing forward for your consideration today is a project that I'm working on where we are looking to get a variance into the OCRM river buffer, specifically for a pool. This is a parcel of land on a little hammock on Dubose Island, or right off of Dubose Island, that has 4 lots. I've designed a house on this lot, and I've also designed a house on another lot on this little hammock. And there are 2 existing homes that were built. One was built, I believe, in the late 80s, and one was built in the late 90s. It's a strange little hammock. I mean, the whole little island is less than a couple acres, and it really is affected by the increase in the OCRM setback requirements that have occurred over the years. When the project was platted, originally the setbacks were 20 feet. Now the buffer is 60 feet. And I think that you guys, this is my first time in front of this board, so forgive any protocol issues. I think you guys have probably seen, many people come in with wanting a pool and going past the buffer and all of that. And I've been involved in some of those in the past too, and have worked with Hillary on other projects. And my intention is always to keep those pools well past the buffer. And in 20 plus years, I've never brought a project in front of this board for requesting the buffer variance until this one. It's an odd little project because of the fact that it's this little island hammock that has buffers on all 4 sides. The zoning is clear in what they state, and this is a very clear case, and the zoning clearly states that you need to have an excessive burden to ask for these pools or ask for variance to the buffer. And I understand the importance of the river buffer, for runoff and drainage. And as an architect, I'm looking at designing these projects. I first have a duty to my client, And next, I have a duty to the immediate neighbors. And next, I have a duty to Hague Point, the community where this house is. And then next, I have a duty to the greater good of the community. And, part of that is protecting the waterways. In looking at this project, we have a big house with a big pool, and, the lots are not large. We are pretty much equal to the other houses that are directly adjacent, and that was something that was very important in designing this project. As you approach this 4-lot hammock, the Shea house is a big house on the right side, on the east side of the island. I'm forgetting the house right in the middle of the island right now, and then there's my house, which will be called the Turner house. The Shea and the other house are there, they're existing. So I tried not to push forward, southward, the proposed Turner residence too much so that it didn't look, out of place with those two existing houses. I submitted an aerial view, maybe if you could pull that up, the colored, it's the last sheet in the submittal. If you go to the last page in the packet, I don't know if it's black and white or if it's in color, but there's an aerial view from the county GIS website where I overlaid the proposed house, and it shows the existing houses. So in designing this project, I not only have to take into consideration the river buffer, which is the specific reason why I'm here for this variance, but I'm also taking into consideration the immediate impact on the two neighboring houses, and also taking into consideration the impact on Hague Point as a whole. So considering the volumes of the neighboring houses in this house, I placed the house several feet southward of the two existing houses, so it will be proud of the two houses as you approach by 7 to 8 feet. I didn't want to push it too much further. One is because I'd have to start getting Hague Point setback variances, and then we get into the OCRM setback on the south side of the island, which on lot one, I came in 2020, and we had that issue on the south side. And in speaking with Hillary about this, she basically said, and Hillary, will speak up. If I were to push the house back, there would be from the zoning board, there'd be more of a preference to approve that sort of variance. But because we've got the house pushed as far south as I feel is appropriate for the neighborhood, we pushed the pool back. So it really didn't want to make like an L-shaped house and ask for a variance on the house because, quite frankly, common sense tells me that creates a lot more runoff. And, the purpose of the OCRM buffer, not only the vegetative buffer, but, the major purpose in my understanding and practice is for the runoff into the waterways. And, where we've set this house and pool, I think, from a professional standpoint, I've been working at Hague Point since 2004. I've done 40 houses there. I'm very familiar with this specific parcel, these specific houses, this little specific hammock. My feeling is that this is the appropriate position for this house and pool. And I do think that, we can mitigate runoff, and my clients would, mitigate any runoff due to this variance, which, I admit is a large variance. It's not, I don't feel that this, if you were to grant this variance, it does not negatively impact either of the two neighbors. In fact, the neighbor to the west, this pool is in line with their pool. And that, I don't know, if, I think that house was built in the 90s, and it was, I don't know if that had a variance or anything, but, there's a pool there now. The house to the east is past where the pool would be. So, this house and pool are all sitting behind, as viewed from the waterway, from the Cooper River there, they're all sitting behind the two existing houses. Now, if we were to pool south, I think that would affect the two neighboring houses in a negative way. And that's really the whole gist of why I'm, here tonight is I'd rather not pool this house south because I think it impacts the neighbors in a negative way, whereas the current siting, and design of this house is the least impactful to the neighborhood, and it also establishes my client's program in the best way. With this pool being on the north side of the house, we don't want to get it tight up into the house too much because then you don't have sun on your pool.
Is this, if looking at number 2, is that the pool there, I guess to the,
Yeah.
I guess that's
Yeah,
number,
that's the pool there on that one.
May I approach or?
I can tell, I can see it. That's the pool right there.
all right, right here, yeah.
Yeah, that line is the edge of the house, and that's the pool on that house, and that's his pool there.
So I came in 2020 with a design on Lot 1, which is at the westernmost tip of this little island. And I was granted an administrative approval for a variance to put the house itself to within 20 feet of this waterway.
How big is that swimming pool?
It's an L-shaped pool.
I can see.
The fat dimension is 18 feet. The long dimension that you see is 32 feet. And then there's a section of pool that is 12 feet long by 50 feet long that runs underneath the house.
12 by what underneath the house? What's this?
All of this is the pool, it's a huge pool. Yeah.
That's what I was wondering.
Yeah, the 50-foot length is part of that 50-foot length is the 18 feet of the width. So you've got the leg of the L is the full length is 50 feet. You can kind of see the kind of the traditional rectangle pool is set there, and then the leg that comes off is 32 feet additional. So you end up with a 50-foot length, which is a lap. That's going to be intended to be their lap pool.
What have you done to minimize the encroachment in your configuring this? What have you done to minimize your encroachment into the setback?
The big thing that was of concern, to me in designing this wasn't necessarily minimizing the encroachment in the setback. It was doing what's right for this island itself in this neighborhood. You have the massing of the pool, so I could have. I feel that we've pushed the house as far south as is practically good for this little 4-lot neighborhood.
Okay.
So to answer your question, we've pushed the house as far south as I think is practical and acceptable to the two neighbors and to my client as well, because you don't want to be right on top of that side. You start getting into the other OCRM setback.
What's the pool deck made out of?
At this point, it's undetermined. These plans are schematic. It could be a pervious material. The pool deck is going to be the main contributor to, hurting the runoff situation. And I would work with the county and my clients to make that pool deck, of a pervious material.
And so-
During normal conditions, the pool itself will, not contribute to, damaging runoff. There's several clusters of live oak that are kind of down in that side too, that I kind of pulled that, part of the house away from.
Anyone else have any questions?
Yeah, I have one.
Go ahead.
That that deck there, that big deck that's right by the stairs, how big is that? What's the dimensions on that?
Are you talking about the pool deck?
Correct. When you come down the stairs and you got that big deck.
That's, that deck is 8 feet wide, and it's 3 feet wide on the side, on the water side of the pool. But the deck itself, the sun deck part of the deck is only 8 feet wide.
Could you narrow that up, bring that pool in a little more?
You know, obviously anything is possible, but yes, that could be narrowed. The issue that that I have with taking that pool closer to the house is that pool's on the north side of the house. So the further south you pull the pool, the more shadows you have all day long on your pool. So that's kind of the reason that
Well, isn't part of the pool already underneath the house?
yes, sir. Yeah.
Just so I'm clear, if you started at the boundary line that's underneath the house on the pool, how many feet from that start up until the 50, up until the setback line?
If you took the part underneath the pool, the part that's underneath the house, to the part that would hit the setback, I've kind of drawn those lines on the paper. This would be an approximation, but I would say that part would be 24 feet maybe, because there's not a great distance. And you know, the reason that we took the pool, the lap part of the pool under the house, was to kind of preserve those oaks on the east side of the house, which, you know, it's hard to kind of see on paper.
And you're not just asking for a variance for the pool, you're asking for a variance of a section of the house that's in the 60-foot.
That's correct, yes. Hillary informed me that would be an acceptable variance, but the pool would not be acceptable. And I mean, I completely, you know, understand on, you know, there's on paper and then there's on site. And, you know, this pool is about the same size as the neighbor pool. So, I mean, you kind of hear the gasp when you say 50 feet for, you know, residential pool and all. But most of that, you know, that could happen, you know, whether we had that variance or not. It's just, you know, trying to get sun. And I mean, I think the big issue, and I mean, Hillary told me I had a 50-50 shot of getting you know, a variance approval on this. I think the big thing would be if, you know, if this was something that you'd grant the variance to, you know, one caveat would be to, you know, really provide extensive mitigation for runoff, and we would, you know, be more than willing to do anything and everything possible, you know, including civil engineer, you know, drainage plan and county check.
What kind of mitigation steps and things like that would you take specifically as to?
Well, I mean, you know, one thing that we had to do on lot 1, for instance, we, you know, I did get the variance on lot 1, but that was for a house.
Mm-hmm.
And in my opinion, a house, you know, a roof runoff is much worse than a pool runoff. I mean, everything's going to run into the pool on a typical situation and then get filtered out through the pumps. What we did in that case was just we addressed it with rain gardens. You know, and I don't know how else we could potentially address it, but I mean, we would be willing to, you know, to work with the county and, you know, create a situation where we didn't, you know, having this pool in this particular spot within this particular buffer would not do any harm to, you know, the waterway and what the OCRM buffer is intended to.
When did your clients buy the property?
I believe they bought it in 2019 or 2020.
So the buffers were definitely in place when they bought the property?
It was established, and when I started this design, I had already designed the house on lot 1 and already had to go through that variance process. We didn't get to this point. It was the zoning committee approved that variance with administratively. So I knew that I knew in this project that there was a good chance that we'd be coming to this meeting. And my clients have you know, advised me that they, you know, would like to see you know, what our chances are. And I mean, I guess what I'm saying is, you know, I understand the rules and I understand that I'm asking for a variance. But I just, you know, want to make it clear that my opinion, as an architect that works in this community, and that is, you know, I've been on this land, is that this is the appropriate siting and appropriate position and appropriate design for this parcel. And, you know, I would like to work in any way to mitigate any runoff.
Why do you need a pool that long?
Laps. The pool is designed for two functions. He's got, you know, your regular swimming pool, which is of average size. It's, you know, 18 feet is, you know, I'd say probably 16 to 20 feet is an average width for a pool nowadays, in my experience, and 32 feet is not a long pool. But the 50-foot kind of leg that goes into the house is for swimming laps.
And how many people are going to swim laps at one time? 4?
Well, typically, they in a residential lap pool, they have a 4-foot width, and this is 12 feet. So, I mean, you could say 3 would swim.
I'm an architect also, and I think that you could redesign this pool and not have it encroach on the buffer so much. I think I'm inclined to send you back to the drawing board to look at it again.
Well, part of the situation with this specific project and coming to this meeting is I'm asking for an encroachment that brings me to within, the pool deck is about 27 feet from the OCRM, or the actual pool is about 27 feet from the OCRM line. The edge of the house is, you know, already at the 60 feet. So anything I do, I'm asking for, you know, a variance into, you know.
Right,
I'm
and we like to work with applicants when you're in a tight site, but we like you to work with us too and not encroach it as much as you are. I mean, I think that there's some other options that you could look at to not have, you know, quite so large of a pool, or reduce the deck, show us how you're going to mitigate it with pervious paving, give us examples of what it's going to do. I think that you could go back to the drawing board and bring us something that we would be more inclined to give you a variance on.
When I guess what I'm looking for then is some guidance, because if the house is, if you would agree that the house is sited appropriately, you know, with obviously not being on the site, but, you know, just taking a professional's word for the house being sited appropriately, you know, anything I do is going to require a variance. So, I mean, how much can we do?
I think you should look at it. I mean, we're not here to design your project. You need to go back and look at it and come back with what is the least impact in the river buffer that you can do.
Yeah, and I mean, I guess what I'm saying is that, you know, I respect that comment, but, you know, as an architect designing this specific project, you know, being on this specific site, my feeling is that this is the appropriate design.
So this is the least impact you were saying right now, this is the least impact of
What
the
I
encroachment?
presented is, in my feeling, the least impactful and the best design for my client and for the specific adjacent clients. In my opinion, the only issue with this design is the fact that it requires such a significant variance. You know, my clients have approved it. It doesn't negatively affect the two neighbors, but I need to mitigate. You know, of course, it could get smaller, and it could get eliminated, and you don't have any variance at all. But you know, just knowing the parcel, you know, knowing the two adjacent houses, and you know, considering that you know whatever I do is going to require a variance.
Thank you, sir.
This is kind of where I've come.
So you want us to make a motion on it and vote tonight? Or do you want to
I mean, I guess what I'd
ask
ask
for
is, like,
continuance and go?
if this were to be continued, I mean, if I come back and I say, well, we've got, you know, we took this back 8 feet, you know, or is it, I mean, how, like, I guess I'm looking for some guidance on, you know, what the board would feel would be appropriate if I was to try to present something, you know, of a lesser impact. I mean, I'd ask for a vote because I feel that this is a design that is fair to the client, fair to the community, fair to the neighbors, as far as, you know, the entire project, not just the OCRM line. I recognize that it has an issue where we need the variance, and that's, obviously that's why I'm here for the pool buffer. But I am, stating that, as a contingent upon approving the variance, that we would need to mitigate.
If we vote and it's turned down, you can't bring it back for a year.
Oh, really?
Yeah.
So that's why we just giving you that option. Do you want to go back?
Well, I mean,
Do some homework,
so
come back before us, or we can vote on it tonight?
Yeah.
that's
And we need the county's comments too.
Yeah. So if you're finished, if we don't have any more questions for you, then we'll hear from the county.
so I guess my last
Your 10
Statement
minutes are way up.
would be, how many times can you come back? I mean, do I bring this back a foot? I mean, like, what's,
I'm not here to give you any advice. I mean, you just have to go back, do your homework, present it back to us, and we'll make a ruling on that.
See what the county.
See, it's county.
Yes, no.
County.
Yes, sir. So the county's actually going to come up.
They can't give you advice, but I'll give you some advice.
Understood.
Thank you, sir.
So I guess kind of reading the board, you guys are recommending no vote.
Just a risk.
You're gonna hear from the county, right?
Mr. Vacaris has shown no hardship for this pool. There's nothing. This pool is an accessory to a home, and the home is the most important thing. They're supposed to be able to build a home. The house sits at 50 feet right now, but this huge pool is sitting 23 feet from the critical line, taking up all of the buffer for a pool. This pool can be redesigned, maybe even move it to 30 feet, 35 feet, but there's no hardship for a pool. It's a want, not a need. And staff recommends this approval because he has not proven a hardship for this. And granting a variance, this is the most that someone would ask for. He's not even asking for a minimum amount of, he's put this 50-foot pool on a tiny lot and hasn't even proven a hardship. So staff recommends this approval because there's no hardship. He can build a house, the house can be at 50 feet, and he can capture all of the runoff, plant a wonderful buffer, and enjoy their home. But this pool does not warrant a variance.
Thank you, Ms. Austin. Any questions for the county? Thank you. So, Mr. Vaccaro. So, you can come back to the podium. What would you like for us to do tonight? I mean, I'm giving you an option now. What would you like for us to do? Would you like to
I'd like
continue
you to
this?
approve the variance.
We can vote on it.
Yeah, I mean,
We can vote on this tonight, or you can go back, ask for a continuance.
I'd like to work with the county, obviously, I've stated I've never, come before this board before, so, what I'll go back and do, and I've talked to my clients about this. I was unaware that there'd be a year, timeframe, but.
If we were to deny it, yes.
Obviously I don't want to, obviously I come here stating that, this is the appropriate design for this specific lot. It's one thing to look at it on paper or an aerial view. It's another thing to be there and.
So you want us to go ahead and vote on it tonight?
Well, I just don't have the confidence, and I don't want to risk my client's time by having a failed vote. So I guess what I'd propose that I'll do is I'll go back and see if I can compromise, but I just, I don't know how much of a compromise.
Well, the county said that they can give you some advice.
Yeah, so I guess that's,
You can come back next
that
month.
seems like the most, responsible thing to do.
So you're asking for a continuance
Yeah.
to our next scheduled meeting, next month?
Yes, I guess.
Okay.
I think that's,
All right, so, thank you. Gotta get someone to make that motion for it.
I move that we continue item number 12 until next month.
Motion been made,
Second.
It's been properly made in second. All in favor?
Aye.
Thank you, sir.
Thank you for your time.
All right. Oh, I'm sorry. Was there any public comment for that item? We close that public comment. So we're moving on to item number 14. Mr. Steve Manning?
Yeah, I appreciate it. This is Steve Manning here. And, can you hear me okay?
Yep.
Yes.
I certainly appreciate the board providing the ability to have this meeting in Zoom. I realize it's not quite as efficient as being there, and wish we could be there. But and also understand that it's not normal protocol. So I do appreciate the board being able to have it in the Zoom meeting. So we're here to try to get a special use permit for short-term rental for 113 Sea Pines Drive. That's over in St. Helena Island. So we've been through the process and understand that the staff review team actually reviewed some of those items and found that that there was actually a covenant over in Coffin Point area that we weren't aware of. And apologize for that. You know, when we bought the house, we weren't made aware of any covenants. Usually when you have an HOA or something of that nature, you know, they present those covenants and things. So, you know, we didn't pay any HOA fees or any of that that nature. So wasn't aware that there were covenants. Not to be an excuse. Actually, when we filled out the form, there's a little block there that asks, hey, are there any covenants? And we went online, tried to find some, you know, that were available and couldn't find any in the public either. So, you know, based upon what the previous owners had stated and what we couldn't find, we didn't think there was. Nonetheless, there evidently, I guess, is one. I don't know if the staff review team actually got a chance to validate whether or not, you know, that's an actual covenant for that area that applies to our residents or not. But if I look at the covenant one that appears to be of issue, it states about whether or not that you have a residential, that all tracts of land in Coffin Point are supposed to be used for residential agricultural purposes only, and no structure shall be placed or permitted to remain on any lot other than the single-family dwelling or outbuilding structures designed for incidental use, such as, and they give examples of private garage, guest house, greenhouse, shed house, or wharf, of which there's none of those on our property. So I'm assuming that they're making the tie that, you know, by doing a short-term rental, that you don't meet the criteria, obviously not agriculture, that it must be for not meet the term residential. I don't know if there's a comment on that, but that's what I can only assume, because I think we meet everything. I actually think I meet residential as well.
Our understanding is that short-term rentals are a commercial use.
That's not true. That's correct.
Yes, because it's a hotel.
And that's kind of, you know, they don't use the term commercial in the covenant. And I think there's a lot of legalities in whether or not it is commercial or isn't commercial. So, you know, I tried to look up the definition of, okay, what's a residential use or residential purpose, and actually found, you know, the Office of Attorney General of the state of South Carolina, he actually had an opinion put out on that, 79-105 that was put out in 79 that discusses, and the definition, the term residential purposes is used for the General Appropriation Act of 1979 is construed to mean any space or area occupied by one or more individuals with the intent of such space or area serves as a residence, house, dwelling, or abode, which it certainly is. So, you know, there's no tie there really to saying a short-term rental is a commercial use. So I think I still meet the covenant that's there. And, you know, when you read it, it's like, okay, well, if that's the kind of tie that you want to make, then even a long-term rental, you know, would fall under that condition that you couldn't rent it out by the year. You know? So I realize this is a short-term rental, so, you know, I'm not going after the long-term. But I think it still meets the covenant as written. So I just, you know, like that to be considered in the review.
Do we have any questions for the applicant?
Yes, there's a form to fill out, a short-term rental safety checklist by, and there are no results on it. I mean, there are no checks.
We did have that filled out, and we actually had the fire marshal sign off on that. It should be in the packet.
Fire marshal signed off?
Yes, he did.
I guess maybe.
Which form is it that you're looking at, Dennis?
It's called short-term rental safety checklist. It's right after the pictures.
Something around the safety checklist.
Yeah, there's nothing checked there.
So do you have a fire safety plan posted?
We do. Yes, we do. Each room has an exit strategy posted that denotes where to exit from, where the fire extinguishers are. That's posted. We have all fire alarms in every bedroom and in the living areas.
Oh, here's the signature.
Any more questions for the applicant? I'd like to hear from the county. Thank you.
When I started with this short-term rental, at first I recommended approval until I heard that there were covenants and restrictions, and I went and I had to find them and review them. The way lodging short-term rental is listed in our ordinance, it's not listed under residential uses. It's listed under offices and services. And that's listed along with hotels, bed and breakfasts. So we consider that a transient use, a commercial use. The house is still a resident, it's still a house, but the use, people come in and going and coming and going, that's not a residential use. That's a commercial use. He gets a business license, he pays an accommodation tax. So staff recommended disapproval because of the covenants that stated residential use only. So that's
So in the short-term rental ordinance, it describes or defines short-term rental as a commercial use?
It's listed under offices and services. It's listed as lodging. And it's for anybody who's renting their home for 30 days or less. That's considered short-term rental.
Is there any more questions for the county? Did you have a question?
No, I think I have a difference of interpretation and opinion as to what constitutes and how the courts interpret what a case law has been that a single family residential still allows for leasing of a property. And if you have covenants and it's going to allow, unless the covenants expressly prohibit that, they're going to determine to allow the freest and best use of the property. And so just because something says single family residential does not mean that leasing is prohibited. And the fact that unless there was a specific prohibition in the covenants as to, hey, short-term leasing is not allowed, and expressly a court's going to interpret that as to allowing short-term leasing. At least as I've had to argue.
Maybe the court can do that. I'm going by the code. The development code states that lodging, short-term rental falls under offices and services. That is not a residential use.
Okay. Well, and ultimately he's applying under our ordinance.
Yes.
Right. I am, but I'm not allowed to give a permit that's contrary to covenants and restrictions. I don't go looking for them, but when I'm given notice, I have to look at them. And if it says residential use only, if short-term rental fell under residence, then no problem. It falls under offices and services. That is not a residential use.
Is there any more questions for Ms. Hillary?
If I might just clarify something for the record, Mr. Bromley, you raise a great point there with regards to, residential prohibition. Under state law, we don't have to go look for covenants and restrictions to make sure that they comply. But if we have been reported that a short-term rental would violate those covenants and restrictions, then we have to not allow it to go forward. If we have not received that notice underneath state law and you all find that the short-term rental request this evening is in character with the residential aspects of the neighborhood, then you're certainly free to vote to approve the special exception.
Because, I represent a ton of HOAs.
Right.
And every single one of the covenants is going to say single-family residential, but then I've also had to be in front of the courts arguing as to how far that is interpreted. And I understand how the courts will look at something like that and how, because it seems like under our ordinance, basically if there's going to be a covenant, we're not going to consider it.
Yeah.
Because everything under a covenant is going to be single-family residential when that's not, if they sued us, that's not exactly how a court would look at it.
Yeah.
Well, we should let the court decide.
Hillary is interpreting the CDC correctly, but short-term rentals are a relatively new phenomenon that didn't exist whenever we wrote the Community Development Code. So you have to take that into consideration. I don't think, had we had short-term rentals back in 2014, whenever we wrote those definitions, then, it might have been clear, but we are going to seek a legal determination from our attorneys on what that means and how far that residential statute would go in covenants and restrictions. But you raise a great point.
Because I think this is an issue that it keeps coming before us and
Yes.
is only going to be in the longer that there's some ambiguity and we keep
That's
walking
right.
in the gray. I think we need some clear, bright lines as to.
And we'll get that from our legal department and get that back to you all.
Thank you, sir. Any more questions for the county? All right,
No, I have one for him, though.
for the applicant?
Yes. Who is going to manage this natural retreats? Is that the manager?
That is correct.
Where are they located?
They're on Sea Island Parkway.
So they're a
just-
local business?
Yes, absolutely. They're right around the corner from us.
All right. I never heard of it.
All right, public comments. Yeah. Yeah, I'll give you a call. Brandy Rains?
Probably not the best person to go first because I don't live in the Coffin Point Homeowners Association area, but I do live at Coffin Point. And I do see the short-term rental effects, the tourists that are coming, the lack of accountability, the disrespect that they have. They're on vacation and they're paying for this and they can take their four-wheelers on the beach and they can let their dogs run loose and they can speed and they can litter and they're not accountable and they don't care. They're on vacation. And I sympathize with the homeowners because I live it too. I'm right close by, but I don't follow under their same covenants. And I'm here to learn because my property has an easement through it and I have different people walking through my yard every week. And I will be here when I learn how to file my own variance and ask you to handle this for me. But I'm supportive of them in their complaint because it's frustrating. This is our residence. We live there, we try to relax there. And there are people there who are not accountable and they do not care. That's all I have.
Thank you. Ms. A. Lanzi?
I do. Can I respond a little bit? Or
No, sir.
Okay.
117 Seapine? Yeah, there you go.
Alexandra Lanza. I live at 117 Sea Pines. And I agree, as the previous person said, that we live there. It's a very peaceful community. It's quiet, it's residential, it's beautiful piece of paradise in a mystical place. But having these people come and speed and litter and drive super fast down our dirt road and create all of this dust for us, let their animals run free on the beach, their four-wheelers on the beach, it's just not acceptable. And it just feels that we that live there protect our world so much with our turtles and our beautiful environment that it doesn't get that appreciation from renters, specifically short-term rentals that are treating it like a playground to just have the beer and toss out the cans and let their kids run free and barefoot and just be crazy. So that's my point.
Thank you. Ms. Kathy McTeer.
I also no longer live there. My husband and I left there last month after 30 years there. His father started Coffin Point Plantation in 1953 and put covenants and restrictions on them when people didn't even know what covenant restrictions were. They did expire in 1975 and they were put back on. These people come to our neighborhood, or what was our neighborhood, and they don't care. They don't care when they set off fireworks all night long. And they don't care when their dogs run loose, and they don't care when their kids are drunk driving golf carts, and golf carts that are trucked in. The majority of the roads in Coffin Point, Sea Pines is not one of them, are private, other than the Avenue of Oaks and part of McTeer. Those roads are maintained solely by the residents in Coffin Point. We didn't buy, they didn't buy to have a Holiday Inn next to us. These people are there, like they said, for a playground, for their vacation. They're paying for it, so they don't care about anything else. And you say, well, call the police and complain. Well, we all know how that goes. And being from a law enforcement background, what's the emergency when you call and say, they're shooting off fireworks? Someone's shooting a gun off across the road. So you don't really want to bother a sheriff's deputy when there aren't a whole lot of them out on the island. But it's not right. This is a residential area. It's where people live. We finally have gotten several families in there with young children. People moved across the street from us with 5 children. They were letting them go down to the beach. I said, wait a minute. There are vacation rentals down there. You don't know who's in those houses. They didn't realize that. And these people don't look at the covenants and restrictions that run with the land. They are not tied to the HOA. They run with the land. And our HOA at Coffin Point Plantation is voluntary. A whole $60 a month. And I'll tell you right now that there isn't one vacation rental person that pays that $60, not a month, a year. $60 a year. They don't even pay that, but yet they want to use the playground and make all the money off of it. I'll say one more thing, we've not only had just vacation rental houses, we've got a house out there that rents rooms. So I think it's got to come to an end. Thank you.
Laura Patterson.
Yes, sir. Hi, I do live in the neighborhood. In fact, I can speak specifically about this property and also the property management company. I have contacted and called out the police 3 times for this specific property. They fire off fireworks. They were drunken, disorderly. The neighbors, the direct neighbors, which are right next door to them, are terrorized. Absolutely terrorized. There's an elderly woman across the street that is afraid to call the police. I was not afraid to call the police. There are 3 neighbors in the neighborhood. We all have little golf carts, and we will get up in the middle of the night at 2 o'clock in the morning and drive to 113 Sea Pines and surround the property and wait for the police to come. I have personally visited their property management company 3 times. There is no one at their office, and when you do get a hold of them, they do nothing. Now, that same property management company manages 2 other properties where they set off fireworks in this neighborhood within half a mile of this house, and they caught the marsh on fire twice. All of this can be verified with the police departments and the fire departments. They are terrorizing us as residents. We pay taxpayer money. In fact, every 3 months, we get out and we pick up all the trash on the road, from our house all the way out to Sea Pines, all the way out to Sea Island Parkway. We are active in our community. We love where we live. We do. I'm sorry, it was a bad investment. You purchased a property where people live and people care about where they live. But the people that drive in for their vacations and they're drinking and firing off fireworks till 4 o'clock in the morning and waking us all up, and that's on a Tuesday night. I can't even tell you what happens on a holiday weekend. It is misery. It is absolute misery, and they're terrorizing us. There is no accountability for it. There are no postings inside the properties to say no fireworks allowed, turn off your lights. We have turtles. We all commonly turn off our lights if we live on the beach so the turtles don't get confused. Not the renters, they don't. Not the short-termers. They got spotlights on outside. They overpark. They're parking on the neighbors' parking because they don't have enough parking, and they just don't care. They just don't care. One of the other ones, not 113, I happened to be riding my horse by the other day. They had 30 people in the front yard, and I stopped to let them to pet my horse. And I said, so where are you from? And they said, oh, we're from upstate. I said, well, is it a birthday party? They said, no, it's a 2-bedroom house. And they had 30 people staying in a 2-bedroom house for 4 days. And this is our neighborhood. We live here. We live here full time, and I can't. And it's middle of the night. It's all night long, and it's every weekend, and it's every Tuesday, and it's every Wednesday. Please.
Thank you, Ms. Laura.
I appreciate it.
Any more public comment for this item?
I just have one comment. I believe we received, this is a public comment, not mine, but what we received as a public comment.
Okay, go ahead.
We received 2, I believe it was 2 letters or requests from 2 individuals.
Yes.
I don't know which one they were talking about, but they're on St. Helena.
Right.
This one of them is one of them.
Because one of them been deferred.
Yeah, so I'm just doing that for the record so that they should be placed in the record, because I don't believe they're here probably.
Mr. Chairman, I'd like to add, aside from the thing, covenant stating for residential use only, number 2 states there can't be any offensive behavior or activities. I believe these folks satisfied that one. They clearly stated there is.
Okay.
You ready for a motion?
All right, well, let me close public comment at this time.
Can I make a statement at all?
No.
No, you had your opportunity in the beginning to state what you wanted to say.
Well,
We normally have given the opportunity to attorneys to come back and speak.
There's just some things that, things that I don't think were accurate. I just wanted to set the record straight.
Somebody in the back.
I put down on my sheet that I want to do 18, but I'd like to speak to this one as well.
Yeah, okay.
Yeah, I do.
Yes, come on, before I close public comment.
Chad Rentz, I live at 77 Avenue of Oaks in Coffin Point community. I came from Pawleys Island, South Carolina, moved here 3 years ago, and when I moved here, I moved into Shadow Moss subdivision, and it was just not what I was looking for as far as low country living. I then found out about Coffin Point because one of my co-teachers, I teach at Low Country Montessori School, and one of my co-teachers lives there, and I went out there and I was like, this is the place. This is where I want to raise my children. I've got a 10-year-old, 4-year-old, and 2-year-old. And after speaking with some of the property owners out there and seeing, actually got a copy of the covenants and was like, okay, I know what Airbnbs are. I know what they bring to the table. This says none. Okay, that was part of my decision in moving and building in this community. And so rolled in there and moved in July, built me a little place out there on the avenue. and I've got my 10-year-old, 4-year-old, and 2-year-old out there, and there's been several incidents where it's just been unsafe for my kids. Kids in golf carts, like nearly running them over. Incidents with dogs on the beach. I've got a golden retriever, and he's the sweetest dog in the world, but those people, they'll ride around in golf carts and shoot off fireworks, and next thing I know, I'm up at 2 o'clock in the morning comforting a dog that won't leave me alone because he's just anxiety ridden. It's really turned into a lot of incidents, and it's a big nuisance. And I just would like y'all to consider that as y'all move forward and make these motions. Thank you.
Thank you, sir. At this point in time, we close all public comments. I'm quite sure, is there anyone who would like to put a motion on the?
I'll make a motion. I move that we deny the special use for short-term rental because it's not in keeping with the residential quality of the neighborhood, and it has been shown that there's detriment to the neighborhood.
I would like to add that it also goes against the covenants.
Right, and it goes against the covenants.
So are you seconding that? Or are you just adding to her motion?
Adding to.
So it's been a motion made.
And I'll accept your addition to my motion.
So there's been a motion on the floor. Anyone like to deny the special use? Anyone like to
second it?
Second that motion?
I'll second it.
So it's been properly made a second. All in favor of denying the special use permit, signify by raising your hand. So this motion has been denied. All right, item number 16. Ryan Hester.
Different. I hope the county clears up this discongruence.
Hello.
How are you?
How are y'all? I'm here for a short-term rental permit as well.
Okay.
27 Maddox, St. Helena.
You aren't in Coffin Point, are you?
Not in Coffin. No, we're on Maddox Drive, just off of Sea Island Parkway.
Is that in Oaks?
I'm sorry?
Is that in the Oaks area?
The Oaks, not that I'm.
Maddox? Okay, go for it.
So, yeah, so we went through the process, and I think we got the recommendation from the staff review team. And spoken with the neighbors, and everyone seems okay with it. I believe there's an Airbnb a couple of houses down that was approved fairly recently.
Where exactly is Maddox Drive?
Right here.
It's just
Right
past.
Okay, that's what I call the Oaks area.
Countryside.
Yeah.
Are there covenants in your neighborhood?
There are not.
Yeah, that's probably not covenants.
No, not there.
All right, so I guess you meet everything. You have all your 3 parking.
Yes, sir.
You meet all the requirements.
Yes, sir.
All right.
There'll be pictures in the packet there.
Any questions for the applicant? Any other questions? Thank you, sir.
Sure.
Do we need to hear from the county? The county?
Recommended approval.
Okay.
We did not have any complaints or any covenants or anything like that.
All right, thank you.
There was one down the street from him on this track.
All right. Is there any public comment for this item? Close public comment. With that being said, anyone like to put a motion on the floor?
I'll make a motion, we go ahead and approve the special use permit for this applicant for a short-term rental.
I second.
There's a motion been made and properly made and second. All in favor of approving the special use permit? It's been approved. All right. Item number 18. Mr. and Mrs. Greg Gardina? Giardina?
Hi, Mr. Chairman and board members. Thank you for joining us. So we
are unfortunately on the Coffin Point area. We're on 48 Saltwind. We're at the Coffin Point area. It was 48 Saltwind. So basically, we're addressing the issue of the covenants and restrictions that the wording of the single-family residence really does not have any explicit restrictions on short-term rental activity in this neighborhood. It does not cover short-term rentals as specifically. So I don't see how that covenant really can apply to this. In general, property laws in South Carolina are in favor of the free use of property. And in the absence of any explicit restrictions, short-term rentals the activity of them should be allowed and have been allowed in the area. There are many in the area that have been approved. And I'm sure they all are zoned for single-family residence as well. Any current commercial restrictions and current CNRs were in place long before this current short-term rental model. Like I said, I don't think it was designed to specifically exclude short-term rentals. And during our 7-month permitting process, we were told that if we had been offering short-term rentals since 2018, that we would be grandfathered in. So there again, kind of shows that there really is not a restriction on there. Also, regarding in the staff's recommendation letter that we got on the 18th, paragraph 5 states that the proposed use may have an adverse effect. I'm guessing on the community. In 2021, we rented for 25 weeks. In that time, the county accepted our higher 6% property tax rate for non-primary residents. We paid a 2% lodging rate on all short-term rental activity, sales tax on all short-term rental activity. Also in that time, we did not receive any complaints from our neighbor, property management or law enforcement. We are on the end of the road on 48 Saltwind. We're on about an acre. We have a huge area for parking. The house is actually at a price point for people who are there to just enjoy the nature, and we have it's a 4-bedroom, but they actually only have it rented, I believe, for 8 people. We do not allow large amounts of people. Our management company is Natural Retreats, and we do have a couple of the people who work for Natural Retreats actually live in our area. They actually they are our neighbors. I would say at least 3 of them, since we had started with them, are our neighbors. And they're very concerned about the other neighbors and offending anybody in the neighborhood. We do have neighbors directly to the left of us, and then we have a neighbor across the street. We have an empty lot next to us on the other side. Those 2 neighbors, they have our numbers. They have Natural Retreat numbers. They know they can contact us 24/7 if there is an issue, but we have not received any complaints from them. We also are prepared because we do love the area. We fell in love with the area just like the neighbors we're talking about. It's a beautiful place. We want to be able to retire there. I mean, that's our ultimate goal. Unfortunately, we can't for a few years. And in the meantime, we wanted to share our house with other people. And we have proposed a letter for an intent to donate as well, just because we do understand that people do believe there are impacts of having people coming in and out. And we would like to use our 10% of our annual net short-term rental profits for either one of the charities on the island, a Penn Center or Friends of Fort Fremont. We want to be able to give back to what we think makes the community so great. And these organizations, they use, sorry, let me just read it. We do realize that we have some, some have concerns over possible environmental impacts and would like to propose a resolution. The above named charitable organizations are located on St. Helena Island. They do provide like the cultural and the historical for locals and for tourists alike, and they provide preservation for the community and support to the community. So we feel like although we have not experienced or had any negative impacts that we know of from our short-term rentals, only really good things about people saying how much they love the area and enjoyed our little private beach that our house has. It seems private because we have no one really right next to us. But we also want to help make the place a better place because we want to live there as well. And so, like I said, we do have a letter that I made copies of that if this were to get approved and we were granted the special use, we would like to donate the 10% profit back into the community.
Is 48 Salt Wind falls under the Coffers Point? Okay.
So we're told, but just like our previous owner, we were never none of that was ever disclosed in when we were signing paperwork.
Okay.
Yeah, we do have the deed. We do have the deed. I don't really see anything specifically towards that, but I do see that we see the covenants. We understand it's in there, but I believe that same wording, single family dwelling, is in. That's the zoning for everyone who has been approved. And like I said, we have people in the area still that are doing short-term rentals. I don't see much different. I do hear their very dramatic explanation of some of the stuff that has been going on in the neighborhood, and I do not agree with that, and I would address that if that were something that we had to deal with, but we have not had any issues or complaints with our property.
Any questions for the applicant?
So you live in California, correct?
We do.
Which is fine, but the people, no, the reason I'm saying is you have people here to watch
Manage
over
it.
to manage it, correct? So
Yes, and our neighbors,
If
yes.
there's anything going on, they inform you?
Yes.
I mean, like some of the individuals that talked in the last,
We have not been in contact with them, but we have been in contact with our direct neighbors. Yes, and with obviously the property managers and with the property managers that live in that area.
Okay.
I have not heard anything.
You do understand that the covenants that what Hillary's talking about, if it's less than 30 days, it's not classified as a non-residential use. So you technically could rent it out on a little bit longer term and have no problem. Right?
That's what we were, yes, that was kind of the confusion, like what's 29 days versus 30 days for us. But yes, that's obviously we can, because of the covenants doesn't really state anything specifically short-term, long-term, I just assumed it covers both, but I realize that's up for.
Well, short term, I mean, looking at your covenant, it says residential or agricultural use or purposes. So once you start renting your unit 30 days or less, you kind of categorize yourself in a commercial use. So at this point, you're in violation of your covenants.
Are the other rentals that have been approved, are they in a non-residential area?
By
They're like the previous one that just got approved on.
They have no covenant.
They have no covenant. I think, although I might agree with your interpretation of single-family dwelling, I think that you're applying for a special permit under the county ordinance, which that classifies as anything less than 30 days to be a commercial use. And hopefully that's some discongruency that the county can clear up at some point. But I think that the ordinance is fairly clear what you're going for.
Makes sense.
Thank you.
Thank you.
Public comment? Mr. Chad Rich, do you need to come back or we just make note of that? Dean,
Morrissey
there you go. Thank you. You can come forward.
Yeah, Dean Morrissey had to leave.
Oh,
He's their neighbor though.
Mark? He left as well?
No.
Oh, that's you, okay.
I'm Mark Heedless, and as a matter of housekeeping, and to give y'all a little bit of history.
Mark, let me just say this. You have up to 3 minutes.
Okay.
Okay.
Okay. All right. Well, can I pass this just to you? It's a copy of your minutes.
It's not necessary.
Okay. All right. With respect to the fact that they have not had any knowledge of sheriff activity, the sheriff has been called to that house on 2 occasions. One for fireworks on the beach, and one for one of their tenants drove down my neighbor's driveway, across his backyard and into my yard in the middle of the night. So those are 2 police reports that you say you don't know anything about, but those are 2 activities on that one house. The incident here is really the covenants, and the covenants that we have do call for single-family dwellings, and once you put multiple people in a single-family dwelling, you now have a multi-family dwelling, not a single-family dwelling. So the roads are private. Saltwind is a private driveway. The vacationers that you have heard about tonight that are coming here that have little regard for anything are coming, if they're staying in a $200 to a $500 house, they're bringing 6 cars, up to 6 cars. Somebody said 30 people in a yard. They're tearing up our roads. Our roads are paid for, maintained by the residents. We can't continue to have commercial activity. The Amazon truck doesn't do as much damage as the short-term rentals do in our neighborhood. That's all I have. Thank you.
Thank you, sir. Pomeroy?
My name is John Pomeroy. I live at 10 Saltwind. I have already one VRBO at 8 Saltwind, which is a neighbor. And now we're looking at people trying to get more VRBOs on Saltwind. Saltwind, if you haven't been out there, is a 2-track, 1-lane sandy road, which makes it very attractive for the residents that live there. And it has a tough time with ambulances, fire trucks, service vehicles of all types that have to traverse that road to serve the residents that are there. Now, when you start adding people to what's already there, it's a dead-end street with no turnaround at the end of it. So fire trucks have just a heck of a time getting around. It's great for the residents. We all have our own way of using our own driveways and things. But when we talk about new people and lots of new people coming in, as I see on 8 Saltwind, the neighbor's house, it's just filled all the time. And the other comments I've heard about not only fireworks, but just all-night activities. They come down from all over the country. It's just amazing, because I'll go out and question some of them about what are you doing and why are you doing it. And it's uncomfortable for me as a resident there and a permanent resident to have to deal with this day in and day out. They're allowed, I think, 2 pets. We see up to 4 to 5 dogs at a time. Supposed to sleep 3 bedrooms, supposed to sleep, you would think, 6 people. We'll see many more people than that staying there during the night. And so I guess what I'm saying is, one, I don't even know if it's legal or approved at 8 Saltwind. And I would ask that question. If it is, fine. If it's not, something needs to be done about it, because it's almost impossible to live next to. One final comment, the neighbor on the other side is now fencing all of his property because he's had so much difficulty with the people that are renting 8 Saltwind. I have my own fence for my dog kennel and things of that nature, which I had to put in once I moved into the house because of the residents that, or the people that come in and use 8 Saltwind. I really am against any additional multifamily VRBO type structures going on Saltwind. It's a limited access and it's unsafe.
Thank you, sir.
Yes.
Mr. Robert, Lorraine?
Hi, good evening, ladies and gentlemen. My name is Robert Lochran. I live at 68 Avenue of Oaks. You come right down my road to get to their road. This isn't personal for anybody. We love it here, and there's a reason why we live here. But let's be honest, 30 days, 31-day long-term rental, you're part of our community, I suppose. You know, we have renters in our community that have been there 2, 3, 4 years. It's really just the 3 and 4 day deal. It's a greed issue. You know, that if I was going to rent my house, I'd rent it for $500 a night. But if I wanted to rent it for the month, I'd probably get $2,500. It's pretty simple. We have people here. I don't know these folks. We'd love to have you as neighbors. We really would. The problem is that when they're not here, their tenant, their guest, as they call them, they're paying them $500 a night to enjoy the beach, but they are also causing lots of problems. Calling the police for fireworks because we think that it might be fireworks or could be gunshots. We're not sure, but at 2 a.m, you call the police. Dogs unleashed, which is a violation of, I think, state law. Running up and down and doing their business on this really nice beach. But I think it's the CC&Rs are in effect. They're pretty plain. We've already heard the previous case for the same thing. And it's, quite frankly, if it was a long-term rental, none of us would be here because those people would be invested in the community in which they live. They don't get to come in for 3 days and have their good time. I work at the local hardware store. I pay taxes to the local. I take care of my community. I take care of the people around there. When I go back to California, where I'm from originally, I enjoy my time there, but it's different. This is my home, and we treat it with respect. So thanks for letting me share.
Thank you. Jerry, Wayne?
Thank you for allowing me to give you some input. I'm the last house on Saltwind. I do not know them. I'm just going to give you some of the horror stories that have happened with rental people. We have 150 acres. We have lived here since the late 90s. We have turned 150 acres, basically not all of it, but most of it, into a bird and animal sanctuary. Currently, this last 3 months, we have got 9 loggerhead turtle nests, and birds constantly are populating. We've got eagles, we've got osprey right in front of the house. It's nature, we love it, we're here for that. Rental, can't speak to them. Rental people right now have brought their golf courts into the middle of this property, buried them in the mud. We had to have a tow truck pull one of these golf carts 300 feet through the mud, destroyed it. Oh, that particular night, it did flood. Too bad. Tore up all the property. It took quite a long time for all that to be replaced.
30 more seconds.
Birds have been eaten by the loose dogs. It's a detriment to the neighborhood. The covenants restrict it. All we ask is that you enforce that covenants.
Thank you, Ms. Vivian. Wayne?
Well, I know you've heard enough about Coffin Point.
Yes.
You can just say ditto and we'll say yes.
Yeah.
That's pretty much what I've got to say.
They always-
But Salt Wind, to begin with, I know John mentioned the roads. Our road is a glorified walking path. It is just wide enough in most areas of it to get one car down. So once you start adding more cars to it, and they say their house sleeps 8. Well, I can't tell you how many times when they've had renters there, they come with no less than 3 SUVs, and there weren't 2 people in each of those. The beach is just crawling with people, and I don't think they have any explanation in their rental that tells them about the beach, where their renters can go and cannot go, and particularly this time of the year when we've got the sea and shorebirds are nesting all over, and they love to get in the shells. You don't even see them, and they come with their dogs. They, assume that this is a play yard for them. Don't have them leashed, and we're trying to be good stewards here to the community. We're here 24/7, 12 months out of the year, and it's a shame that the havoc that people cause, over a weekend and feel like they're entitled to it because they've paid for it.
20 seconds.
And so I'm just, everything that everybody else has said is true.
Thank you. Ms. Elaine Smith?
Ditto.
Thank you. Well, that closed public comment. With that being said, everyone have heard what's all been said. Can I get a motion? May I?
I move we deny the special use permit.
Second.
Because of the
Motion been made to
covenants?
deny based on the covenants, the special use permit. It's been properly made and second. All in favor? That covenant, that's been denied.
Mr. Chairman?
Yes.
If I could make one statement for the record, for those of you in here in Coffin Point, if there are those other short-term rentals in Coffin Point, if you'll provide us with the addresses so that we can investigate those, we would appreciate it.
Very soon.
Oh, yes, I know it. Bruce Beasley. William Smith. Well, he's representing Bruce Beasley.
Oh, okay.
What does it say there?
Good afternoon, sir.
Good afternoon, sir. How you doing, sir?
You can go ahead.
Okay, yeah. I'm here in the matters of 10 Sea Island Parkway. It is a rural neighborhood, and we're just coming for you.
Hold on one moment. Excuse me. Excuse me. You said 10 Sea Island Parkway?
1044.
Okay. That's and you are representing Bruce Beasley.
Yeah, I'm representing Bruce Beasley. I'm the property manager.
Okay.
Bruce and Sharon Beasley.
As you were.
Yes, sir. And basically, it is a rural neighborhood. The house sits right there, right on the corner, and we don't have a covenant.
So you've satisfied all your checklists for this short-term rental?
Yes, sir, I have.
You said there's no covenant?
No, there's no covenant.
Okay. Any questions for the applicant? Okay. Any public, thank you, sir. Is there any public comment for item number 20? No public comment, we close public comment. Can we get a motion?
I move we approve the special use permit.
I'll second.
So a motion been made to approve the special use, and second, all in favor?
Aye.
It's been approved. Sally Rock is requesting a special use permit.
Could you speak up a little bit?
Special use permit for short-term rental for my property on 26 Pineland Avenue, St. Helena. It's not in a neighborhood, no covenant or restrictions.
Pineland Avenue. Where's Pineland located?
If you go down Eddings Point and turn on,
Oh, in Eddings Point.
yeah,
Okay. You said there's no covenant?
it's not in a neighborhood.
And you satisfied all of the checklists that's required, the
Yes.
parking, fire?
So you live in Mount Pleasant. Who oversees it?
PMI Sea Island, they're located in Beaufort.
Go ahead.
Ma'am, I have a question for you. I'm looking on your sheet and you, it's a 4-bedroom house and you're gonna allow a maximum of 10 people? It's what you have on your application?
There's a loft that has additional beds. It can only be, it's not conditioned, so it can only be used. There's 2 queen-size bedrooms, so that was 2, 4, and then there's 2 sleeping rooms. Kind of, it's a fish camp, so it's a little different. And then there's a sleeping loft that has some single beds up there.
Okay. So it could handle 10 people?
Yes, there are 10 beds.
Okay.
There are 10.
10 beds?
Well, there's 8 beds.
Okay.
You know, 2 people per queen
2
bed. I'm sorry.
Okay.
Not to confuse everyone.
Okay.
Any more questions for the applicant? Thank you. Is there any public comment for item 22? Is Pat Cook still here? No? All right. So then, we close that public comment.
Excuse me. There's a couple of us here.
There is some public comment?
Yes, sir. Mr. Chairman.
Did you guys fill out?
Yes, sir.
Is this one of them? No, you said Pat Cook wasn't here.
Okay, could you come up and state your name? And you fill out one of these forms?
Yes, I did. David.
26 Pilot. Okay. Go ahead, you can state your name and.
Good evening, everyone. I'm Sarah Reynolds Green. I live on Pineland Avenue, and I don't know her. And I do know that we have a wonderful, quiet neighborhood. And when fish camp, well, I want to go back. The environment is very conducive for what we do, in which we have an organic farm, and we work with the youth. So there are lots of children in our area on the farm on many occasions. And the property that's in question was a fish camp. And we've had many problems with that fish camp because of in and out residents, short-term residents coming in and out. Same thing as other ladies were saying. the fireworks, the loud noises, the parties, and things of that nature. I have not met her, and I think she just got the property, correct? Or you? And so, but my concern is what the other people were saying. I want to be proactive in our community, and I want to make sure that our community remains residential, and we get to know our neighbors, we get to meet our neighbors and be a part of a neighborhood. And I don't like what I'm hearing. That doesn't mean that this is going to happen to us. And I don't know what kind of provisions or restrictions a covenant has, but I know that what we've had in the past from the fish camp residents that came there, we want to see that again. So I would like to keep our community rural and residential and a neighborhood, and not a short-term rental back and forth with different individuals that are rowdy and disruptive and disrespectful.
And you said that, obviously, you, go ahead.
I was just, have you had any issues there with the house?
With the fish camp, when it was a fish camp, it was, I guess, I don't know how they used it, but I know different people would come.
It wasn't a rental, so I don't know if they used it.
Yeah, but I know it wasn't.
It was owned
they
by a
weren't
bunch
there.
of people, maybe.
Yeah, I don't know what the qualifications for the house being there, but as a fish camp, I don't know what the residents were required to do, or the owner was required to do in terms of who comes and goes, but we had problems. We called sheriff department a couple times because of the noise, and of course, they said, well, they have the right to do whatever. The guns going off, target practice, or whatever, things of that nature. Not her, but when it was used as another, fish camp was used as another.
And obviously, that's your community, so there's no covenant there, right?
No, not that I know of.
Thank you.
Thank you.
Danny? Culverton?
I'm Danny's son, Wes. I signed up also. I'm here because I don't want him to speak on this. He's got a surgery scheduled for a cyst on his vocal cords in August. And my mama told me I better come here and talk.
You got up to 3 minutes.
Thank you.
Wes?
Mr. Chairman and members, there's some other things going on here. Rather than resurrect the horse and keep on kicking the horse, we got the same issues, ditto, plus we're trying to square up with this application that we got from county staff, thankfully, that states the CO on this property. In other words, what the county building official approved in 2015 when it was built, 480 square foot, one room. DHEC gave that structure permission to come in with what you call a cat box septic system. Okay, so that was based on one room. So now you've got before you, and staff would have no way to know. This is a similar situation with the covenants. How do you go and find this unless somebody brings it to your attention? So thankfully we're here tonight, and thankfully you guys are hearing what we have to say about this. But DHEC says you can do a forced pumped cat box system for that one room. So what happens when you don't have power? What happens whenever you have 10 people, which is in the application, they keep flushing the toilet, keep running the sink, keep doing whatever? It's coming out of the ground. It's not a traditional gravity flow system where it stops and backs into the house. It's coming in above the ground. This septic field, by the way, is too close to the property line. It's in the northeast corner, if you're looking at the submitted plat. The northeast corner is not shown in that plat. It's left blank on the application as to what type of septic system there is. Also, the ditch goes straight to Eddings Creek, right through this septic system. Eddings Creek shellfish harvest has been shut down by DNR due to fecal chloroform in exceptional levels. 60% reduction needed according to DNR. I got all this I can hand in if you need to, but the DHEC study of the shellfish station there, the closest one to this parcel, says too much fecal chloroform already. So if the board could consider that, we'd be grateful. And also, please consider that access to this property is by private driveway serving 5 residences. My mother and father have got 3 parcels on Pineland, 66, 70, and 71. So Ms. Reynolds Green's here and my father's here. They're basically the 2 predominant property owners on Pineland. Everybody else they've talked to, they know everybody. My father and my mother have been there since 2014. Really, they came in and were kind of camping with an approved septic field since 2008, 2006. But anyways, trying to feel the neighborhood out, see if they want to move down here permanently, did everything the right way, what have you. And I'm ironically up here telling you, don't let anything in that area become a short-term rental, because the only issue they had with not building down here was, man, that party house down there, they're shooting guns and doing whatever. I mean, we don't know those people. And so here we are, and we're kind of in shock. So we appreciate your time, and I can answer any other questions, and I can submit documentation if needed.
So you have documentation stating that we said a 400 square feet?
480 square feet on the CO, and the building official came back. That was January 2015. The building official came back in June and inspected, and the same thing's on there, 480 square feet.
So the rest of it was built without a building permit, is that what's?
Correct. The rest of it on all this documentation to the county for approval to get the CO, to get the power cut on, is you got a screened porch, open screen porch, and then you got a covered porch. And then you got underneath. So I don't know how they're getting to 1,300 square feet. I don't know who sold them that, but it's unfortunate, but that's the reality of it, and that's what the county should consider. Again, our main issue is what's going to come out of the ground and what's going to happen to the road. The private road, which is a dirt road, of course, as you probably guessed.
You're saying that they're on a septic tank? Is that what you're saying?
They're on a cat box. It's a forced pumped-in system.
So it's like a sewage disposal?
Correct.
Yeah, okay.
Like similar to a grinder pump, the way it.
I just wanted to make sure on the check thing here. Gotcha.
I can pass up that DHEC study too if you need.
Please.
Mr. Chairman.
Yes, sir.
Is it in what you are?
Yeah,
Okay.
I gave you.
And it's a 20-foot wide private drive for 5 homes. So then you throw the short-term rental, transient people in there. You know, it's just, again, it's just kind of something we would thank you to not characterize that as being consistent with the community, to have transients come in on top of everything that's already going on.
Thank you, sir.
Thank you.
Is there any more questions?
Hillary.
Okay, we'd like to hear from the. Okay. I think that's the end. Is there any more public comment for this item? Excuse me? So we close the public comment. We'd like to hear from the county.
After listening to these 2 people and I looked at the tax record and I realized that this building is only 480 square feet. So I don't see how you can get 4 bedrooms out of that. So I'm being a little bit, I think I want to change my recommendation from approval. I don't see 10 people in a 480 square feet building. And I'd like to change my recommendation from approve to disapprove. Because I don't think the septic system and the size of the building, unless she can bring something back from building codes that they, added on and the tax assessor picks it up. Until then, I would recommend disapproval.
Thank you. Based on the evidence that's been presented before us and the testimony we've heard today, would someone like to place a motion?
I move that we not approve the special use due to the environmental impacts of the property on Eddings Creek.
Second.
I'll second it.
So it's been, the motion's been made to deny the special use permit, and it's been properly made and second. All in favor of denial of the special use permit? It's been denied. So moving on to item. That's been
Down to the last one, buddy.
moved, deferred.
The auto body shop.
That's on another page, that's right. I thought I was finished.
24, we made it.
All right, number 32, Mr. Jonathan Best. Requesting a variance. Yes.
You have a very well-behaved little girl.
I was about to compliment you on your child's behavior. I've got my kids would not hit.
I don't know, I'll tell you, I'm gonna have to bring my grandkids here to let her see how to act. She doesn't take after her father, I'll tell you that.
Yes, sir.
How are y'all this evening?
Tired.
I think we're the last one. Ours is quick and easy, hopefully. My name's Jonathan Best. I own Better Collision Centers. We're local out of Charleston. Our first store was open in Charleston. Our second store is right here in Beaufort County, actually. So we're right on Industrial Village Road. We have a third store in Monk's Corner in the Charleston market, and we're trying to hopefully open our fourth store right here in Bluffton. We were already starting process on it. We thought zoning was cleared, of course, and somebody missed it in due diligence that there was a variance set for residential neighborhood. So I believe we're applying for a special use permit.
Variance.
Variance, okay, forgive me.
I'm looking for that.
We are looking to request a variance to get acceptance to put our collision center in.
Okay, I know I have it.
And this is right on 278, correct?
Yes, ma'am. I think one of the concerns were, and forgive me, I don't have all the information with me. We were trying to get here in time. We had a work day and try to get here from Charleston. But I believe some of the concerns were the views of the shop from the property behind us. We did a walkthrough. It's pretty far away from us, I think 150 feet. And there is one heck of a tree line back there. I mean, I didn't even know there was property back there. That's how thick it actually is. You cannot see us back there. I'm not even sure if that's even a worry more than just kind of an opinionated thing from people not wanting to see us. But we didn't spare any expense in regards to what we were designing. We wanted to make sure it felt like it fit into the community. We changed some of our colors. You'll see the darker color image on the front. Typically we go with the brighter blue, but just to kind of make sure it blended well into the community, we went with a darker color just to hopefully appeal to the city for you guys. And Ms. Hiller, I think one of the other problems was the ventilation of the shop, visibility. So we upgraded and put a kind of like a barrier around the filters up top.
So it looks like a chimney up there.
So it's kind of like a chimney. Yes,
Okay.
sir. You can't see it. One of these pictures here will kind of show you. It's on the smaller sheet. It's down at the bottom. It says number 3 on it. This one here. You can actually see the trees that are actually already in place, so you can't really even see that chimney if you wanted to. And the building's pretty enormous, so it's towards the back right side of the building. So when you're driving down 40 Island Road, you actually can't see that chimney.
Forgive me, I'm
Here.
looking for your application. I knew I had it here.
Here, you wanna look at mine?
I got too many papers shuffled around.
That's why I numbered all mine, because there were so many.
I did too, but yeah. I know it was a concern about the footage of like 250 feet.
Yeah. That's the variance.
Yeah. All right.
Now,
Did you say you have auto body shop here in Beaufort?
We do, yes,
Did you
sir.
take over the old, were you here before?
Well, I used to be the CEO of Fendamender Group out of Charleston.
No, did you come before this board? It seemed like I remember someone
Oh, no,
coming
no.
before that board.
Not us, no. We did buy out Earl's Body Shop.
Yes.
3 years ago now, so we've been there
Something
for
like
3 years.
that, yes.
Happy neighbors, by the way. All our neighbors are happy.
Alright.
We keep it clean, and we've been fixing vehicles for 3 years now. I'd say we've probably, just since the time we've been here, we probably repaired in Beaufort County at least 10,000 vehicles.
Jeez. You say we're bad drivers?
No, Charleston's way worse. We actually enjoy it here.
It's more behind here. It's behind me. If you looked at, I looked at the site plan, I mean, the neighborhood plan, and it's like, here's 278, here's this one, and there, you know.
Well, looking at this, it looks like you've taken all the
not Best Buy,
necessary precautions for any kind of noise pollution or
Number 2.
any particulate pollution and all that stuff.
Absolutely, yes, sir. I think actually the car wash that's right next to us would be more worrisome on pollution than
Half
you
of them are
would with us.
commercial uses, but there's houses in here.
How many parking do you have in
And there's
there?
a driveway
How would
that
you
goes-
store? I think
the
I
road that
remember
goes
reading
here,
that your parking
and
is
then
gonna be
they
stored
call
in
it
the
access
inside
lane
most.
that way.
All
The letter
we
that was
during the day,
written,
cars come
people were
into the.
concerned about that.
They're always going to be behind the fence. But during the day, we do pull the wrecked cars out. They are in the enclosed fencing area, just so we can move production through the buildings. But in the evening, we do store all the wrecked cars in the building. So most you have outside is inbound vehicles and outbound vehicles ready for delivery and ready for intake and ready for outtake.
One of the letters we got from neighbors were concerned about the access road back to the neighborhood. I mean, what kind of traffic do you have? What's your sort of daily traffic load into your?
How many vehicles?
Yeah.
We only schedule in about 5 to 10 vehicles a day, and all of our customers are scheduled. We do it all through our app. We're very strict on that because we really can't process with only so many cars. I would say on average, I mean, when you say back road, which road are you talking about? I'm confused. I apologize. I just wanna
Well,
make
the
sure.
access road, it seems like the road that comes off of 278, I was just looking online.
This one right, oh, to get into our property?
Yeah,
So it actually looks like it, I mean, when I pulled in there, I didn't even realize that was an access road. I just assumed that was our driveway. You can go right or left immediately when you pull in.
okay,
I would say on average, maybe 20 cars a day.
okay. How many employees do you have there?
10 to 15 employees, 10 to 15.
Is that access road shared by other businesses?
The access road, I'm not,
I was looking online at the Google Maps, and you might have a direct entrance off of 278, but there's also,
have a direct, I know what you're talking about.
but there's a road that
Yes.
runs along the side
So
of.
that's not us, by the way. That's a whole, there's a bunch of commercial businesses to our left. And there's a little strip mall there, a few units, and then there's some doctor offices in the back. So we will not be on that road
Okay.
at all, actually. Forgive me, I was trying to make sure I knew what you were looking at there.
Right, well, when you're looking at Google Maps, you're not always quite sure what you're looking at, so.
Is there any more questions for the applicant? Thank you, sir. I'd like to hear from the county.
Thanks, guys.
County recommended approval because we thought that the use of this building, I think it's been sitting empty for a while. And the body shop, the code requires that it be at 250 feet from a residential, and there's apartments behind. So my suggestion would be pull the paint booth, farther away from the rear of the property. And he submitted some extra stuff about the noise and all that other stuff. So that would be our recommendation, that he ensure that these things are in place. And hopefully there'll be no complaints. If there is, then we'll read. But we recommended approval because he seems to be he's going to take the necessary precautions to reduce the noise and odor pollution. So, and then the building itself, our or design review board will look at it. If he's changing anything, he's changing the colors, and I guess this chimney thing will be looked at and maybe hidden from 278. So it has to go through our final development review team.
And the
So-
design review will look at the buffer between his
Yes.
property and the residential
Yes.
neighborhood.
Yes, okay, so all the landscaping and all that stuff will be reviewed by the design review board. And that, yeah, that letter stated about that back, access. I looked and I saw that, but I don't know how that access came to be, so.
Okay, yeah, that's what
Yeah.
got me looking at it. I was
Not sure if he would even use it.
And just so I'm clear, the supplemental materials, I believe, that was where it shows the new fan and duct, is it your position that this fan and duct needs to be moved closer to the front of the property? Or is that?
I thought the paint booth was a booth itself, right?
It is a
And so the booth itself should be moved closer to the front, away from the apartments. So I guess this is just a rendering, I'm not sure how it's gonna be, but we are recommended that the paint booth itself is not, I think I measured 200 feet from the property line, so.
Is that because of noise, or you're concerned?
Well, I'm thinking the odor, I'm not sure what's coming out of these paint booths, and, you know.
Well, he got a thing here, he's got charcoal filters where there's not gonna be any odor, and the sound is at 63 decibels.
That's right.
So plus you're gonna encase it in a soundproof box.
Just to go the next.
So I don't think that's gonna be an issue at all.
Okay, so, I mean, if everything he says he's going to do and he does it, and this thing on top will be looked at by the design review board to make
Right.
sure it's not just this ugly thing sticking out, so.
And so that wouldn't need to be a condition of any approval of
No,
ours,
'cause they
that'd
already
be in
have to
front
go
of
before the design-
He has to
board.
come before the design review board anyway, yeah.
Thank you.
The variance that just, because we've had so many of these, the variance that he's asking for tonight is to be 87 feet instead of the 250, close to the residential.
Yes. Well, I'm not sure where see, what I drew showed the
Just trying to figure out what we're voting on.
paint booth.
It just says closer than 250 feet. We don't know what it is.
200 feet from the rear property line. So I'm not sure where you're going to put the paint booth, on the outside of the building?
It's inside, it's inside.
It's inside the building?
Yeah, that's what I'm wondering, if it's
Oh, well,
inside the
then-
building, what
then
are
I'm
we?
okay then.
Okay.
Yeah, what are we
Yeah.
talking about? What are we trying to?
I just
thought
thought a
it
paint booth
under
is
something.
outside.
I got
you.
You're thinking the
You
old
tired,
days.
Hillary?
I guess.
Did
All right.
That's what was really bothering me about the.
That makes sense now. I
Yeah,
can understand.
that's when I called you and said, yeah, so.
So the existing the back of the existing building is 87 feet from the property line.
And so the variance before us is approval of that because the setback is 250.
Yes.
Yeah.
Right, and it was, and you had approved, and it was staff's recommendation is to approve.
Yes, yes.
We will need you all to make a condition that all the noise attenuation, all the conditions associated with the permit, make that a part of your motion,
Right.
if you will, please.
Yeah.
Well, with that being said, who would like to put that motion on the floor?
Looks like John's about to make it.
All right, I'll make it. I make a motion, we approve the variance, provided that he has proper noise attenuation, which would include putting the compressor in an enclosed room with sound deadening walls.
I'll second it.
So the motion is to approve with the certain conditions that's been properly made and second. All in favor of approving the variance, signify by raising your hand. Thank you, sir. Your variance has been approved, sir. Any old business, new business, adjournment?
I move we adjourn.
Motion to adjourn, can I get someone to second?
Second.
Second, all in favor?
Ah.
All right.